So, good morning, all of you. In the last class, we had started our discussion on the preamble. We had discussed the basic things about the preamble, and we were discussing the key words which are there in the preamble, and we had discussed the concept of socialism from the examination point of view, especially from the prelims point of view. Now coming to another term that is there, it is secular. And we have this word secularism. Now, coming to the meaning of the term secularism, secularism is religious neutralism on the part of the state no state religion, means there will be no official religion of the state. There can be some other statements with respect to secularism in the prelims examination. You can write some other statements also. The state shall not concern itself. The state shall not concern itself with religious beliefs, practices and institutions. Next, the state shall not be associated with a particular religion. Next, the state shall permit freedom of conscience, beliefs and religion for all its citizens. Then next, the state shall not discriminate between the citizens on the basis of their religious beliefs. So there can be such type of statements in the prelims examination, that which of the following statements are correct about secularism. Not only this, basically this concept, the statements that we have written here, these statements are mostly associated with the Western concept of secularism, and in the Western countries, there is a wall of separation between the state and the religion. But when we talk about the Indian context of secularism or the dimensions of Indian secularism, we have the Gandhian view and the Nehruvian view. The Gandhian view of secularism is of Sarva Dharma Sambhava. That is, coexistence of all the religions basically. Gandhiji was talking about this concept of Sarv Dharma Sambhava in the context of India's freedom struggle, that if people of all the religions, they will come together, then unitedly we can fight in a better way against the British. That was the logic of Gandhiji. That is why he talked about this concept of Sarva Dharma Sambhava, or the coexistence of all the religions. When we talk about Pandit Nehru held that a secular state has got three characteristics. ये भी आप लिख लो. For Pandit Nehru, a secular state carried three meanings. First, freedom of religion or irreligion for all. Freedom of religion or irreligion, IRR, irreligion for all. Secondly, the state shall honor all the faiths equally, and thirdly, the state shall not be attached to one faith, or religion which by that act becomes the state religion. So in the examination, even if the name of Pandit Nehru is not there, which of the following is correct regarding secularism? Any of the statements that we have written, That can be asked because secularism is in the news and it is always in the news in the country. So whether the student has got the basic idea about secularism or not, that can be tested. Not only this, so in a nutshell, if we say that then secularism in the context of India may mean equal treatment to all the religions. That is the summary, equal treatment. So the scholars, they have summarized, it is equal treatment to all the religions. Now when we talk about Indian secularism, there is a legal dimension of secularism in India. First of all, Article 15, it prohibits the state from discriminating among the citizens. Citizens on the ground of religion along with some other grounds. So there are other grounds which have been mentioned in Article 15, but as we are discussing the concept of secularism, that is why I have mentioned only religion. Then Article 16 provides for equality of opportunity in public employment for all the citizens here also the state cannot discriminate among the citizens in public employment, that is the job under the government, on the grounds of religion, and other grounds are also mentioned. Then Articles 25 to 28 provide for freedom of religion to all means all living within the territory of India, to all as fundamental rights. And then Article 326, it provides for right to vote to all the citizens so here also It is universal adult suffrage. So any person who has attained the age of 18 years, irrespective of his religion, caste, sex, he has the right to vote. So we have a legal dimension of the we can say secularism in India. So such questions can be there in the prelims examination to test your understanding. Apart from it, which of the following statement is correct regarding Indian secularism? In India, we have got positive secularism. The word positive secularism is there. It is not divorce from state and religion. The state will provide you conditions and equal treatment is given to all the religions. Then, so these are some aspects which can be there in the examination from secularism. Then coming to democracy. Democracy is a combination of two words, demos plus kratia. Demos means people and kratia means rule. So when we say democracy, it is ruled by the people or rule of the people. Now, trying to develop an understanding about the concept of democracy. Democracy basically has got some dimensions. First of all, democracy as a form of government. When we say democracy as a form of government, here it will include presence of more than one political party, then regular elections, based on universal adult suffrage, rights and liberties, enjoyed by the citizens, freedom of press, rule of the majority, but with constitutional recognition of minority rights. Now, in the prelims examination, there can be a question, which of the following is a feature of liberal democracy? Because in the liberal countries, we have got these aspects. So they may not ask you this democracy as a form of government, but yes, which of the following is a characteristic or a feature of liberal democracy? So these are the features of liberal democracy. It is not multi-party system. It is presence of more than one political party, because in some of the countries we have got bi-party system also. So you need to have a general idea about the concept of democracy. क्योंकि ऐसे भी देखो आप, in your prelim syllabus we have got a topic political systems. So democracy, dictatorship, that is also a political system. So पहले तो democracy, dictatorship, then within what is the relationship between the executive and the legislature, parliamentary and presidential. What is the relationship between the central government and the state government, unitary and federal. So this is the structure. Now there is another dimension or another connotation of the term democracy. It is democracy as an ideal. Here we mean the substance of democracy. We are talking about a democratic society. So a democratic society is that society where prevails justice, liberty and equality. When we talk about Karl Marx, Marx was of the view that the state will wither away. So with the withering away of the state means when there will be a classless society, the state will not be there. And obviously if the state will not be there, democracy as a form of government will no longer be there. But Marx talked about a democratic society where there will be justice, where there will be equality. Not only this, in the common terms also, what we say, we talk about democracy as a virtue. आप लोग ऐसे भी घर पे कभी कभी क्या बोलते हैं? If your parents are very strict, my father, he is a Hitler. So it is a symbolic one. That is, oh, your father, my mother is also a Hitler. So it is a symbol of dictatorship. That is, in our family, our parents, they hear to no one, they take arbitrary decisions, we are not consulted. You may have heard that the persons living in a dictatorial, in a monarchy also, they use the term democratic for their monarch. Our king is democratic because he gives importance to the principles of liberty, equality, he gives justice to everyone. So it is the virtue that is there. Apart from it, there can be some other statements which will be there in the prelims examination with respect to democracy. Here you can write, democracy is based on rational thinking. rational thinking. As the decisions are arrived at by discussions so rationality is the basis of democracy. Where in which of the countries democracy can be a failure? Where people will not behave in a rational manner. They will choose their representatives on the basis of the parochial identity. So there the democracy may not survive. Rationality is the basis of democracy. Such type of statement will be there, rational thinking. Now coming to another area from where the questions can be asked from democracy in the prelims examination, it is the types of democracy. We are discussing democracy as a political system. Broadly speaking, in some of the countries, direct democracy and indirect democracy. In a direct democracy, people directly participate in the process of governance. Whereas in indirect democracy, it is ruled through the representatives of the people. It is also known as representative democracy. So in India, we have got this representative democracy or indirect democracy. In most of the countries, we have got indirect democracy. We elect our representatives and after that we forget and let them work, and after that again in the elections we elect our representatives. Now here we are concerned with this direct democracy even from the prelims point of view. There are 4 devices of direct democracy. Initiative, referendum, recall and plebiscite. Initiative is a device by which people initiate the laws to be made, and it is not 5 people, 10 people or 100 people. They will go to the government and say it is direct democracy, you make a law on this. If the majority of the people wishes a law will be made on that topic. Initiative. When we say referendum, a law is made, then it is referred to the people for their approval. And if the majority of the voters they approve, then only the law will be implemented. Just as we vote in the elections, people vote that yes or no. That is referendum. A law is made, it is referred to the people for their approval. In indirect democracy, what happens? A law is made by the government, it is signed by the head of the state, it is notified in the Gazette, and it is implemented. Then the people come to know about it. But here, the law will be implemented only after the approval of the people. When we say recall, recall is a device by which the elected representatives can be called back if the majority wishes. So, in between the term of the representatives, if the people feel that our representative is not delivering, then they can pass a resolution, means the majority of the voters, then he can be called back. And plebiscite is a device by which the views of the people can be ascertained on an issue of political importance. Suppose if tomorrow the people of Jammu and Kashmir are asked that whether Jammu and Kashmir will be a part of India or not, or if Jammu and Kashmir should be given autonomy or not, such questions where we can say it is plebiscite. So, here in case of referendum, a law is made, it is referred to the people. Here, the views of the people can be ascertained on question of public or political importance. In the prelims examination, easy questions can be expected. Which one of the following is a device of direct democracy? 1 and 2, 2 and 3, only one, such questions can be there. Then republic, you all know what is the meaning of the term republic? Head of the state is an elected one, he is not a hereditary monarch. That is why 26th January is celebrated as Republic Day, because from that day India had become a republic, we had an elected president, and it was on 26th January, that is on the morning of 26th January, Dr. Rajendra Prasad had taken oath as the President of India. That is Republic Day. Then coming to the other aspects from where the questions can be asked. Justice, social, economic, and political. Now from here, which of the justice has been envisaged in the preamble? You see, we have no legal justice, social, economic, and political. These three words you need to remember, that the preamble envisages social, economic, and political justice. Social justice has to be achieved through Articles 15, 16, and some directive principles. Then economic justice is to be achieved through Articles 39 clauses B and C. And political justice is to be achieved through some fundamental rights and Article 326. In the Constitution, you will see two types of numbers. One having capital A, capital B, capital C. So wherever you will see capital A, capital B, capital C, it means that these articles were not there in the original constitution. They were added later on, and they are separate articles. They are not the part of the earlier article. But whenever you see like this, small b, small c, these are clauses of the main article. So wherever it is clauses, small b, small c. Now, coming to the term liberty, the preamble talks about liberty of thought, और क्या है वर्ड, क्या क्या है, क्या याद है आप लोग को? लिबर्टी ऑफ थॉट, एक्सप्रेशन, बिलीफ, फेथ एंड वर्शिप. Liberty of thought and expression, it is mentioned in article number 19, clause 1, subclause A. Belief, faith and worship, articles 25 and 26. This is the first set of questions that can be there in the examination from the preamble with respect to liberty, that the preamble envisages which types of liberty: liberty of thought, expression, belief, faith and worship. There may be some other statements with respect to the understanding of the term liberty. So there you can write here as note. Note number 1. Liberty means absence of restraints. Liberty means absence of restraints. Basically, this is the idea of negative liberty. That is, and the classical liberals, means when the liberalism was initially introduced, the classical liberals basically, they were of the view that the state was a necessary evil, and all restriction, all restraints, qua restraint is an evil. There should be no restrictions on the freedom of the individual. So liberty is absence of restraint. That is the first meaning. Second, note number 2 you can write. Liberty is the presence of conditions under which an individual can enjoy his or her freedom. So, through the Constitution, the conditions will be there where the individual can enjoy his freedom. This is the concept of positive liberty. You see, when during the Industrial Revolution, this concept of negative liberty was prevalent, and under the influence of negative liberty, the states did not enact the labor legislations, no economic policies were made, and that is why exploitation had started, and the industrialists, they started to exploit the workers. Then I may have told you in the last class also that when the economic inequality became rampant, then Karl Marx challenged the ideology of liberalism. So when liberalism was challenged by Karl Marx, then the liberals transformed their view from this concept of negative liberty to the concept of positive liberty. That is the concept of a welfare state. That the state will provide you the conditions where you can enjoy the freedom. Through the constitution, those conditions will be given. Now, in the prelims examination, if both these statements are there, you need to encircle the concept of positive liberty. Because in a welfare state like India, we provide opportunity, we provide those conditions in which the individual can enjoy the freedom. It is freedom through the state. Negative liberty is freedom from the state. The more you are away from the state, the more you will be happier. But here it is freedom through the state. So in the examination, if both the options are there, you need to encircle the concept of positive liberty. Then note number 3 you can write, law and liberty are not opposed to each other, but law is a necessary precondition. Law is a necessary precondition of liberty. So, such understanding based statements may also be there in the examination. So, it is not that in the absence of law, we will be enjoying our liberty. If law is not there, we will not be able to enjoy our freedom. Why? Otherwise, it will become matasya nyaya. That is the survival of the strongest. So, that is why there has to be law. So, law and liberty are not opposed to each other. Such type of statements may also be there in your exam. These are unplanned statements which may be there in the, so you need to have an idea and understanding. So, this was from this concept of liberty. Then preamble also talks about equality. Preamble talks about equality of status and of opportunity. Equality of status has been mentioned in Article 15 and opportunity has been mentioned in Article number 16. So you see that the words are here and we have got the relevant provisions inside in the Constitution. That is why the preamble is termed as the philosophy of the Constitution. That is, it contains the philosophy of the Constitution. Then from here, the most important questions will be from liberty. Questions are often asked from liberty, a basic understanding of liberty. From justice, which of the justice has not been enshrined in the preamble? Then, which articles of the Constitution aim to achieve the end of economic justice? Articles 39 clauses B and C. Whereas I will tell you again when I will be discussing the directive principles of state policy with you. Then, the preamble talks, it has got another word, that is fraternity. Fraternity is the concept of universal brotherhood. The concept of Vasudhaiva Kutumbakam. So everywhere there was the posters of G20 and everywhere it was written Vasudhaiva Kutumbakam. So Vasudhaiva Kutumbakam, it reflects the preambular objective, that is the objective of the preamble, that is to promote fraternity. So in that way we need to understand this concept of Vasudhaiva Kutumbakam. It was there in the G20 का जहां भी आपने देखा ना लोगो, वहां पे लिखा है ना वसुधैव कुटुंबकम. हाँ, so that is associated with the concept of fraternity. So Vasudhaiva Kutumbakam is an objective of the preamble. Such type of questions may be expected depending on your understanding, that whether you have understood that symbol of G20 or not, because it was very important event for India. So from the preamble, such type of questions can be expected from the keywords. So first part we had discussed, and the keywords we can expect such understanding based questions. Now moving to part 1 of the Constitution. The Union and its territory. Before I proceed further, I will tell you some questions which have been asked in the previous years from the preamble to have an idea about it. For example, in 2021, there was a question that what was the exact constitutional status of India on 26th January 1950? What was the exact constitutional status of India on 26th January 1950? What was the status? Sovereign Democratic Republic. Done. So such type of question. Then in the same year there was another question: which of the following factors constitutes the best safeguard of liberty in a liberal democracy? A committed judiciary, centralization of powers, elected government, and separation of powers. Separation of powers. Committed judiciary nahi. Committed judiciary, last class mein bhi I had told you, it is a negative concept. So when we say separation of powers, means there should be separation of powers with checks and balances. Then only there will be, the liberty will be safeguarded. If one of the institution, it will work against the people, the other organ will come to the rescue. Understanding based questions are there, based on the theory of separation of powers. Then in 2019, the question was, or 2020, the preamble of the Constitution of India, in effect, a part of the Constitution but has no legal effect, not a part of the Constitution and had no legal effect either, part of the Constitution and has the same legal effect as any other part, and D, a part of the Constitution but has no legal effect independently of the other parts. D, a part of the Constitution but has no legal effect independently of the other parts. That is what we had discussed in the LIC case. इलेक्टेड रिप्रेजेंटेटिव कोई गारंटी थोड़ी ना, इलेक्टेड रिप्रेजेंटेटिव तुम्हारे पाकिस्तान में भी है, हाँ, सब जगह है. सो वो दैट इज अ डिफरेंट थिंग. इलेक्शन तो कहीं भी आप करा सकते हो नेम के लिए. Yes. Committed judiciary is a negative concept. This I had told you in the last class also. It is a negative concept. Committed judiciary here in this sense will mean a judiciary committed towards the government in power. That is committed. Independent judiciary hota, that would have been the correct answer. So if there is difference between independent judiciary and committed judiciary. Committed judiciary is the negative concept. जैसे बोलते हैं committed bureaucracy. So committed bureaucracy is a positive concept. क्यों? Because the bureaucracy has to be committed to the government in power. Any government which is elected by the people, the bureaucracy must be committed to it. It is not commitment to the constitution. वो बोलने के लिए है. Because in a parliamentary form of government, the bureaucracy thrives under the cloak of ministerial responsibility. And the people, the people have shown the trust in the government. And it is the responsibility of the bureaucracy to work. So, wahan pe committed bureaucracy is committed towards the government. Commitment towards the government in power. Otherwise, the country will not run. But here, committed judiciary will not be. Here, separation of power. So, that is why you need to develop such understanding. पूरा चीजों को जब तक समझेंगे नहीं आप, you will not be able to answer this question. क्योंकि इतना ऊपर से रहता तब तो सब लोग compete कर जाते. Elected government, सब कर जाते. So that is why whether you have understood the concept of separation of powers, because separation of powers has to be read along with checks and balances. So yes, the aspect you have to understand. Then in 2019 there was another question in the context of polity. Which one of the following would you accept as the most appropriate definition of liberty? It is protection against the tyranny of the political rulers. Second, absence of restraint, opportunity to do whatever one likes, and opportunity to develop ourselves fully. D, it is opportunity to develop ourselves fully. It is the state will provide you conditions. The state will provide you opportunity for your development. So, मैंने कहा one is positive, other was second. So, words will be different in the examination. The words will not be there. You will have to develop an understanding. यही तो इसीलिए तो मैं बोला कि प्रोफेसर्स जो होते हैं ना यूनिवर्सिटी के वो पेपर सेट करते हैं आपका. मैंने उसके बाद क्या बोला कि अगर दोनों ऑप्शन आएंगे तो कौन सा आप सही लिखोगे. ये भी मैंने कहा था कि अगर दोनों रहेंगे देन पॉजिटिव कॉन्सेप्ट. देन 2018 में there was another question related to liberty. Which of the following state is the nicest appropriate relationship between law and liberty? If there are more laws, there is less liberty. If there is no law, there is no liberty. If there is liberty, laws have to be made by the people. If laws are changed too often, liberty is in danger. If there are no laws, there is no liberty. So ऐसे ही है. One of the implication of equality in the society is the absence of क्या होगा? Privileges. यहाँ पे absence of privileges. And then the mind of the makers of the Constitution of India is reflected in which of the following? Preamble. तो अब वही है कि if you have not known, अब सिर्फ आप बेरुबरी यूनियन केस में आप पढ़ के चले गए कि नहीं preamble is not a part of the Constitution. लेकिन उसमें क्या कहा था? It is the key to the open the mind of the constitution makers. That is our understanding. Then democracy's superior virtue lies in the fact that it calls into activity the intelligence and character of ordinary men and women, the methods for strengthening executive leadership, a superior individual with dynamism and vision, a bond of dedicated party workers. चार ऑप्शन एक बार और बता देता हूं. क्वेश्चन है डेमोक्रेसीज सुपीरियर वर्च्यू लाइज इन द फैक्ट दैट इट कॉल्स इनटू एक्टिविटी फर्स्ट द इंटेलिजेंस एंड कैरेक्टर ऑफ ऑर्डिनरी मेन एंड वुमेन, सेकेंड द मेथड फॉर स्ट्रेंथनिंग एग्जीक्यूटिव लीडरशिप, थर्ड अ सुपीरियर इंडिविजुअल विथ डायनामिज्म एंड विजन, एंड फोर्थ a bond of dedicated party workers. First, a superior individual dynamism and vision. डेमोक्रेसी सुपीरियर वर्च्यू, डेमोक्रेसी वो तो मोनार्की में भी हो सकता है. सो हियर द इंटेलिजेंस एंड कैरेक्टर ऑफ द ऑर्डिनरी मैन, दैट इज रैशनल ह्यूमन बीइंग्स, रैशनलिटी. इसलिए मैंने कवर टर्म आपको, दैट इज व्हाट आई सेड कि यू विल हैव टू डिडक्ट द थिंग्स. आई विल बी टेलिंग यू द कीवर्ड्स कि चलो रैशनलिटी, तो इसमें क्या हुआ, द इंटेलिजेंस. रैशनलिटी कौन किस में होता है? A person who has got intelligence as well as character. So rationality is the basis. Such type of questions are being asked in the examination. That is why I told you many things. ये तो बहुत easy है. Which one of the following objective is not embodied in the preamble to the Constitution of India? Liberty of thought, economic liberty, liberty of expression, liberty of belief is not embodied. Economic liberty. So आप देखिए लिबर्टी के अराउंड कितना क्वेश्चंस गया. दैट इज व्हाई वी गेट द ट्रेंड दैट व्हाट टाइप ऑफ क्वेश्चंस, पीवाईक्यू से यही फायदा होता है, बिकॉज द यूपीएससी हैज सेट दिस क्वेश्चन पेपर. ये नहीं कि लक्ष्मीकांत से उठा करके क्वेश्चंस आपको दे दिया टेस्ट सीरीज में, जो कि इतनी सारी जो दुकानें बैठी है वो क्या करते हैं, लक्ष्मीकांत से उठाया दे दिया बच्चों को, ठीक है, आर्टिकल उठा के दे दिया, फैक्ट्स दे दिया. इसमें कहां भी एक भी नो फैक्ट्स हैव बीन आस्क्ड. You see, your basic understanding of democracy, your basic understanding of liberty, that has been asked in the examination. That is why I told you that even in the prelims examination, you need to go beyond Lakshmikant. You need to go beyond Lakshmikant. Then only you will compete in the prelims examination also. अब ये सब वर्ड्स कहाँ लक्ष्मीकांत सर लिखेंगे? कभी नहीं लिखेंगे. ये चीज वो तो पूर्व जन्म का कर्ज है आप लोगों का, जो लक्ष्मीकांत को चुका रहे हैं. हाँ, अरे इतने लोगों ने कर्ज ले रखा होगा बेचारे से, इस जन्म में हम लोग चुका रहे हैं उसको 300-300 रुपए 4. अरे कुछ बच्चे तो उसको क्या करते हैं, दे बाई एवरी एडिशन ऑफ लक्ष्मीकांत. शायद कुछ चेंज रहा हो, पढ़ता कोई नहीं है. नहीं, मुझे पता नहीं, आई हैव नेवर रेड दैट बुक. तो ये चीज है. अब दैट इज अ साइकिक है. वो तो टीचर अगर नहीं बोलेगा कि डोंट रीड लक्ष्मीकांत, द टीचर नोज नथिंग, ही इज आस्किंग अस नॉट टू रीड लक्ष्मीकांत. वो तो स्टूडेंट साइकोलॉजी है, उसमें तो स्टूडेंट का तो बात ही छोड़ दो बेचारे का. हाँ, उसको तो क्या है, स्टूडेंट को क्या है. आजकल तो वो रील में टीचर्स आ जाते हैं, उनको लगता है कि बस यही आईएएस बनाता है. तो वो स्टूडेंट बेचारे का तो छोड़ो, वो तो ही इज सफरिंग. वो स्टूडेंट का छोड़ दो, ठीक है. हम तो वी आर प्रोफेशनल टीचर्स, वी फील दैट आवर स्टूडेंट शुड कम्पीट, रियली कम्पीट इन द एग्जामिनेशन. ये चीज. नाउ कमिंग टू, तो आप समझ गए, यू हैव गॉट एन आइडिया. Understanding based questions have to be there, and if you can apply your presence of mind also, you will be able to answer the question. So try to develop an understanding from the very beginning. Now coming to part 1, the union and its territory. There are 4 articles, that out of that we need to understand 3 articles. First, article 1, India, that is Bharat, shall be union of states. Shall be union of states. Now, when we say shall be a union of states, here comes your first question from the prelims point of view. The Constitution of India describes India as, the answer will be union of states. ये चीज है. So nowhere the word federal, quasi-federal, federation has been mentioned in the Constitution. If the question is, which of the following best illustrates the nature of the Indian state, then quasi-federal or federation with a strong center, whatever is the option. But if the Constitution of India describes India as, the answer will be union of states. There was a bit of controversy this year with respect to the word Bharat. So the Constitution recognizes Bharat also as the name of India. इसमें भी कोई कंफ्यूजन नहीं होना चाहिए. दैट इज वाई दिस आर्टिकल इज इंपॉर्टेंट फ्रॉम दिस ईयर्स प्रीलिम्स पॉइंट ऑफ व्यू. क्योंकि व्हाट दे हैड डन इन द G20 समिट, क्या किया था इन्होंने, लिखा था रिपब्लिक ऑफ भारत, ये चीज है. सो द वर्ड भारत हैज बीन रिकॉग्नाइज्ड बाय द कॉन्स्टिट्यूशन आल्सो, एंड द कॉन्स्टिट्यूशन ऑफ इंडिया डिस्क्राइब्स इंडिया एज यूनियन ऑफ स्टेट्स. नाउ for your basic understanding, when we talk about article number 1, India, that is Bharat, shall be a union of states. Why not the word federal, federation has been used in the constitution? Our constitution makers had in mind the American system. America also terms itself as a federation, but America is the result of an agreement among 13 British colonies. So, and they had signed an agreement among themselves. And when you sign an agreement, you have the right to secede also. So, our constitution makers had that thing in mind, that the Indian Union is not the result of an agreement among the units, but the idea of India was already there. What had happened? That the states in India were created in accordance with the law, that is, in accordance with the provisions mentioned in the constitution, mostly because of administrative reasons. So, it is not an agreement among the units. So, it does not mean that in America the states have the right to secede. No. क्योंकि now, देखो, earlier there were 13 states. और ये तो पूरा एक डेवलपमेंट है, पॉलिटिकल डेवलपमेंट टेक्स प्लेस, एंड ग्रेजुअली द सेंट्रल गवर्नमेंट बिकम्स वेरी स्ट्रांग. हिस्ट्री का टीचर आज भी बोलेगा कि नहीं नहीं ठीक है, इट कैन secede, but it is not feasible now. Originally there were 13 states, now we have got 50 states in America. And when Abraham Lincoln was the president of America, some of the units tried to secede. Abraham Lincoln sent a message, clear cut message: if you want to secede with America, you will have to fight war with America. Because now that was the question of sovereignty of America. So gradually the things change. But we use the word union of states. Now here you can write as note. Note number 1. The summary of Article 1 is, the summary of Article 1 is, India is an indestructible union. India is an indestructible union. Then, note number 2, the territory of India, the territory of India consists of the territories of the states, the territories of the states, union territories, and such other territories as may be acquired So in the prelims examination, 3 questions from article number 1. Constitution of India describes India as, what will be your answer? Union of states. ठीक हो गया आपका काम. Then when we say summary, India is an indestructible union, The states have not created the union, they have no right to secede from it. Clear? That is why the word union of states have been mentioned. That is why when any state tries to secede with India, the central government deals it with iron hands. The states have the units have no right to secede. And then thirdly, the territory of India consists of the territories of the states, the union territories and such other territories as may be acquired. ये बहुत कम पूछते हैं, ये आपके स्टेट पीसीएस वगैरह में पूछ लेंगे, but yes, the two questions I told you, they are important. Article 2, even if you will not read, it is not that you will not compete in the examination. You can omit article number 2, कोई दिक्कत नहीं. Now coming to article number 3. Article 3 authorizes the Parliament to alter the areas or boundary or change the name of a state. There is no need to mug up Article 3 also. You need to have a general idea. No one is going to ask you what is Article 3. In the prelims examination, from Article 3, the process of the creation of new state can be asked, because that is the main aspect which is there in article number 3. You may be aware about the general lawmaking process in this country. First of all, when the government decides that we need to have a law, then the concerned ministry, it prepares the draft of the law. And the draft of the law, that is the proposal for legislation, is known as the bill. If someone will ask you what is a bill, the bill is proposal for legislation, and the draft bill is prepared. After that, the draft bill is approved by the cabinet. The cabinet is the highest decision making body of this country, which is headed by the prime minister, and it consists of all the cabinet rank ministers. In the coming class, I'll tell you about the cabinet also, some facts. And after the cabinet approves the bill, it becomes the official bill of the government of India. And then the bill is introduced in the houses of the parliament. And then it is passed accordingly. And after getting the president's assent, the bill becomes the law. But when we talk about the creation of new state, here the request can be from any group. It can be from the state government, it can be from the people also. And principally, once the central government decides that we will have this state, then the process will start. For example, suppose we need to create Vidarbha. Suppose Vidarbha is to be created, means Maharashtra is to be bifurcated into Vidarbha and Maharashtra. So it will be reorganization of. So first of all, the bill will be drafted. and after the approval of the cabinet, these things are not mentioned in the constitution. Then after that, it will not be directly presented or introduced in the parliament. First of all, it will be referred to the president. Without the recommendation of the president, the bill cannot be introduced. The president will first send it to the concerned state legislature, and the state legislature will have to give its views within a specified time, not consent, views. And after the lapse of the time frame, it will be presented or introduced in the parliament, and the parliament will have to pass the bill by a simple majority. And after the president's assent, a new state will be created. This is the basic understanding. Now some points you can write here. The draft bill with respect to the creation of a state, is prepared by the Department of States. In bracket you can write Ministry of Home Affairs, MHA, Ministry of Home Affairs. So exam में ऐसे भी पूछेंगे which of the following department is associated with framing the bill or making the bill for the creation of a new state. So ministry तो सबको मालूम है MHA, but which specific department? It is Department of States. Then next point you can write, such a bill can be introduced in either house of the parliament, on the recommendation of the president. Next, the president must refer the bill first to the legislature of the concerned state, for expressing its views within a specified time. Underline views. Next, after the lapse of the time frame, it is assumed that the state has given its views. Next, after that the bill is to be introduced in the parliament. Parliament means either house of the parliament. Next, in the parliament, even if the bill undergoes a large change in content, it may not be referred again to the state, to the concerned state. So suppose in the original bill that was referred to the Maharashtra State Legislative Assembly, it was mentioned that 15 districts will be carved out and Vidarbha will be created. But when it is presented in the parliament amends it that 18 districts will be taken from Maharashtra and Vidarbha will be created. So this bill may not be referred to the state legislature again. That is what we have written. Then next, the parliament is not bound by the views of the state legislature. The parliament is not bound by the views of the state legislature. Next, the parliament has to pass the bill by a simple majority. The parliament has to pass the bill by a simple majority. And after getting the president's assent, a new state is created. So this is the process. इसमें कभी पूछ सकते, ये वाला जो टॉपिक मैं आपको पढ़ा रहा हूं ना, ये बी वाला बी कैटेगरी में आएगा. मतलब हाँ, ये बी कैटेगरी है. इट इज नॉट ए कैटेगरी. ए कैटेगरी वाज प्रीएम्बल. It is B category topic. So sometimes, suppose in the year in which you will be appearing in the prelims examination, if a demand for a new state is going on, then the question can be asked from here. Article number 1 is A category. वो सिर्फ एक क्यों? Because there was a controversy with respect to भारत. कुछ लोग बोल रहे थे कि you are trying to change everything in India. So India के बदले भारत क्यों? So there was lot of rumor in this country also. कि now the Bharat will be official name. There will be nothing called India. Then तो ये जो भारत वर्ड है ना, so that is why article 1 may be important. Otherwise ये state formation they may not ask. Now here you can write as note, NOTE. The summary of article 3 is the states in India are destructible. The states in India are destructible. Then note number 2, the summary of articles 1 and 3, India is an indestructible union. India is an indestructible union with destructible states. So the union is indestructible, but the states are destructible. So article 1 and 3, this is the summary. नहीं, one time only. वो तो आपने लिख लिया है क्या? अरे नहीं, वो तो मैंने बोला ही नहीं लिखने के लिए, मैंने तो वो बोला ही नहीं था। मैंने आपको समझाया था कि हाउ अ बिल बेसिकली इज जनरली प्रिपेयर्ड. So in principle, first of all, the draft of the bill is prepared, then there is approval of the cabinet. After that, the bill is presented in the parliament. That was a general idea I gave. But here in this case, after the approval of the parliament, the cabinet, it is not written in the rule, we can say the constitution. So after that, what happens? That the constitution, how it starts? That such a bill can be introduced in either house of the parliament with the prior recommendation of the president. Done? Lekin president will recommend when? Before recommending it, the president will send it to the concerned state legislature. इसलिए मैंने ये बना के आपको बताया कि डायरेक्टली ये नहीं, यहां से हो जाएगा, then the president will say कि चलो ठीक है, it will be introduced now. So this is the process that need to be followed. ये चीज. Now coming to article number 4. Article 4 clause 1. By the department of the state. Then the bill can be introduced either house of the parliament or the recommendation of the president. फिर आपने उसका president को representative concerned state. And then after they are doing and then again come back to the parliament and then debate and then some debate and the benefit of the president and law will come. So this is the goal of it. Such a bill can be introduced either in the house. नहीं, वो आपने लिखा है कि दैट कैन बी इंट्रोड्यूस. तो यहां आने से पहले द रिकमेंडेशन ऑफ द प्रेसिडेंट विल बी रिक्वायर्ड एंड द प्रेसिडेंट बिफोर इट. हर एक चीज इज नॉट मेंशन्ड इन द कॉन्स्टिट्यूशन. वो समझते हैं कि हम लोग को समझ है, ठीक है. सो बेसिकली, सो हियर द प्रेसिडेंट फर्स्ट ऑफ ऑल ही विल बी सेंडिंग द, इसलिए हमारे कॉन्स्टिट्यूशन का जो लैंग्वेज है ना, इस बोलते हैं इट इज अ लॉयर्स पैराडाइज. आप और हम अगर आप पढ़ोगे ऐसे तो इट इज वेरी डिफिकल्ट फॉर यू टू अंडरस्टैंड ईच. इसीलिए मैं स्टूडेंट्स को बोलता हूं, डोंट ट्राई टू रीड इट वर्ड बाय वर्ड, नहीं तो वो ऑट शूट सैल में 4 साल बीत जाएगा, ना कंप्लीट करोगे ना कॉन्स्टिट्यूशन समझ पाओगे. यस, इसीलिए मैं आपको अपने भाषा में समझाया कि बेसिकली हियर व्हाट विल हैपन, दैट it has to be introduced in the parliament, either house of the parliament, on the recommendation of the president. But before the bill is introduced here, in between this happens. Now coming to article number 4. Article 4 clause 1. Holds that, holds that a law under article 2 or article 3, shall contain the provisions for the amendment of the first schedule, and the fourth schedule, as may be necessary. ये रटने की जरूरत नहीं है, तो मैं आपको इतना लंबा जानबूझ के बताया. आपको ये याद रखना. अच्छा, if a new state is created under article 3, then there will be an amendment in schedule number 1 and schedule number 4. This is the summary. डन. ये चीज अब ये आपके आर्टिकल 4 क्लॉज 1 में इट इज मेंशन. ये क्या होता है, देख, सपोज इफ अ न्यू स्टेट इज क्रिएटेड, सपोज विदर्भ हैज बीन क्रिएटेड, so in schedule number 1 there will be an amendment and the name of Vidarbha will be written here. Bidar will be written here. Then in schedule number 4, the representation of the states in the Rajya Sabha has been mentioned. Here also there will be an amendment. The representation of Maharashtra will change here, and here a new addition will be Bidar. A new addition will be Bidar. So in Article 4 Clause 1 it is written that a bill which will be introduced for the creation of a new state will have such provisions for the amendment of schedule number 1 and schedule number 4. ये लिखा हुआ है. So it will be an automatic one. Then here you can write Article 4 Clause 2 holds that Article 4 Clause 2 holds that no such law, or a law ऐसा लिखना, a law made as per Article 4 Clause 1 holds that a law made under Article 4 Clause 1 not to be considered, not to be deemed or considered as an amendment of the Constitution, as an amendment of the Constitution for the purposes of Article 368, for the purposes of Article 368. So, you see, when we talk about an amendment, isko bhul jao what is written in the Constitution. Try to develop an understanding in your mother tongue. So, basically such type of statements will be there. And here if you say, it is an amendment to the Constitution. It is an amendment to the Constitution. Because what you have done, you have written the name of a state in schedule number 1. Here schedule 4 has also been amended. So it is an amendment to the Constitution. But in Article 4 Clause 2 it has been mentioned that any law which is made under Article 2 or Article 3, that is new state is created, and if changes are made in schedule number 1 and schedule number 4, they are not to be considered as an amendment for the purposes of Article 368. It means the process which is mentioned in Article 368 of the Constitution will not be used here. It will be an automatic amendment. A new state will be created, that reorganization bill will be passed, automatically the names will be added here and the changes will be here. There will be no separate procedure that will be required. So it means that it is an ordinary bill. It will be passed in the form of an ordinary bill, even though it is an amendment to the Constitution. So such type of questions can be asked in the examination, that which of the following is not to be considered as an amendment of the Constitution under Article 368, creation of a new state, or amendment in schedule number 1 and schedule number 4 after the creation of a new state. No doubt it is an amendment, but it will be an automatic amendment. Separate bill is not to be passed in the Parliament under Article 368. Now, when we talk about the dynamic aspect of Part 1 of the Constitution, when the Constituent Assembly was enacting the Constitution, then they basically put the names of the state in schedule number 1 in the form of 4 groups or 4 categories, A, B, C and D. But at that point of time, the merger of the princely states was taking place, and there was a general agreement in the Constituent Assembly that these 4 categories of states, they should not be the final one. You should think of reorganization of the states as soon as possible, because there was uneven development, there was linguistic concerns. In some of the princely states, 2 or 3 languages were spoken. So it was held that it should be a temporary one. You explored the possibility of the reorganization of the states. Then the government started exploring that whether the states should be organized on the basis of language or not, and it constituted some commission and a committee. From the prelims point of view, that can be important. Heading you can write linguistic reorganization of the states. Linguistic reorganization of the states. (1948) Dhar Commission. Justice Dhar was a judge of Allahabad High Court, and a commission was set up. So here you can write Dhar Commission to examine the case for the reorganization of the states, on linguistic basis, full stop. The commission favored reorganization of the states, on the basis of administrative convenience, rather than linguistic considerations. rather than linguistic consideration. तो सिर्फ आपको रखना है धर कमीशन, linguistic reorganization of the states. Then in the same year, that is in 1948 only, the Congress constituted a committee of its own members, popular as the JVP committee. J for very good, V for and P for Pattabi Sitaramaiya. कहाँ से पुट्टू स्वामी लिया है? Pattabi Sitaramaiya. So Pandit Nehru, Sardar Patel and Pattabi Sitaramaiya. JVP committee. So this was a committee of the Congress, and it was to look into or to examine the issue of the reorganization of the states on linguistic basis. This JVP committee also rejected the idea of linguistic states. But as the politicians say, these people also said that the matter can be looked into if the demand comes. And the demand came in 1953. And in 1953, in the Telugu speaking areas of Madras state, there was a hunger strike by Sri Ramalu. He went for a hunger strike for 56 days and demanded a separate state on the basis of language, that is Telugu, in the state of Madras. He died, but the central government succumbed to the pressure of the death of Sri Ramalu And in 1953, Andhra was created as the first linguistic state. Not Andhra Pradesh, Andhra. So Andhra was created as the first linguistic state. After that, all the states started demanding that we should also be reorganized on the basis of language. So in December 1953, the central government, it appointed the States Reorganization Commission. State Reorganization Commission. It was headed by Justice Fazal Ali. That is why it is also known as the Fazal Ali Commission. And it consisted of the other members K.M. Panikar, and H.N. Kunjru. It was the States Reorganization Commission headed by Fazal Ali which had recommended the linguistic reorganization of the states. So the Fazal Ali Commission, likh lo, this commission recommended to do away with the fourfold classification, means khatam kar dena, to do away with the fourfold classification of the states as provided in the original constitution, and recommended the reorganization of the states on the basis of language, as well as administrative convenience. After that, in 1956, the States Reorganization Act came into force and it provided for 14 states and 6 union territories. You can write the name of the states. The States Reorganization Act 1956. Provided for 14 states and 6 union territories. How many of you belong to the states which were created in 1956? You belong to which state? You are from Odisha, okay. यू आर फ्रॉम बिहार, ओके। बस यही 2 स्टेट क्रिएट हुए थे। तुम किस स्टेट से हो? उत्तराखंड से। वो कब बना था? अच्छा, ठीक। तुम तो बाद में बने थे। So only 2 states. I said 14 states. You may not be aware about it also, but you need to know. You can write the name. Andhra Pradesh, Bihar, Bombay, Jammu and Kashmir, Kerala, MP, Madhya Pradesh, Madras, Mysore, Orissa, Punjab, UP, West Bengal and Rajasthan। 14 हो गए, 13 हुए। क्या मिस हुआ? असम मिस हुआ, ठीक। असम शुरू में आई वर टॉकिंग अबाउट 1956। अभी तो काफी चेंजेस हो गए हैं। बॉम्बे इज नो लॉन्गर देयर। नहीं, वो तो मुंबई कैपिटल है, वो तो स्टेट था बॉम्बे। हाँ। नाउ coming to the union territories, 6 union territories were there. Andaman and Nicobar Islands, Andaman and Nicobar Islands, Delhi, Himachal Pradesh, Tripura, Manipur, Lakkadive, Minicoy, and Amenability Islands। and Amenability Islands एक ही है। This was original one. Now what you will have to do is that one thing that you need to do, you need to remember the name of the states in chronological order, especially the northeastern states. And in the examination, what type of question can be there? There will be the name of 4 northeastern states. You will have to arrange them in the chronological order of their creation. Your keyword will be Assam. Assam, the first one. So if Assam is the first option in, we can say 2 of the options, then you can eliminate. उसके बाद you need to know. ये ध्यान दे रहे हैं, ठीक है? तो वो आप अपने से कर लेना कि ये शेड्यूल 1 में the list is there. Now coming to part 2 of the constitution, that is citizenship. If I ask you who live in the state, so what you will say? Citizens. You have not seen foreigners here in Karol Bagh. The individuals live in the state. 2 types of individuals they live in the state. The citizens and aliens. Aliens means the foreigners of friendly states and of enemy states. No country is an enemy country during peacetime. Only when we are at war with that country will be termed as an enemy country. So no country is India's enemy country now. When officially we will be at war with the country, that country will be termed as an enemy country. Now the next question, ये तो ऐसे continuity के लिए I have told you. Now the next question before us is, who is a citizen? A citizen is an individual who enjoys full membership of a political community that is, he or she enjoys all the legal and political rights so it is associated with the rights. Full membership of the political community. Which of the following statement is correct regarding the, we can say correct regarding a citizen? So he will be enjoying all the legal and political rights. Now the question before us is, which rights are exclusively enjoyed by the citizens of India? First, right against discrimination. Article 15. Then right to equality of opportunity in public employment Article 16. Then 6 democratic freedoms. Under Article 19, Clause 1, the right to freedom of speech and expression, right to assemble, right to association, right to move freely throughout the territory of India, right to reside and settle down in any part of the country, and right to have an occupation. These 6 democratic freedoms are exclusively enjoyed by the citizens of India. Then, cultural and educational rights. Articles 29 and 30. These are also known as minority rights. Then right to vote, Article 326, then right to hold constitutional offices under various provisions beginning from the office of the president. What is the qualification? Must be the citizen of India. Judges, CAG. So that is what we have, right to hold constitution under various provisions. Now from here, two questions can be asked in the examination. One, which of the fundamental rights are exclusively enjoyed by the citizens? These are the fundamental rights which are exclusively enjoyed by the citizens. Then if the question is which of the rights, then koi bhi hoga, you can encircle it. But if it is fundamental rights, then right to vote will not be encircled here. Only these rights. Then you will ask me that, sir, if a list is there in the constitution, no. Wherever the word citizen has been mentioned, it means it is available only to the citizens. You see what is mentioned in Article 15. The state shall not discriminate against the citizens. Against citizen. Not only this, in Articles 29, it is mentioned any section of the citizens of India. Any section of the citizen. That is why we say that the minority rights are available only to the citizens of India. So here, everywhere you will find citizen. Even in Article 19, Clause 1, every citizen shall have the right. So that is our key word. So from there we have deducted it, that which of the rights are exclusively enjoyed by the citizens. Rest all the rights are enjoyed even by the foreigners who are living in the territory of India. Right to life, right to property, even right to property. Then in fact, if you say your right to personal liberty, then apart from it, right to freedom of religion, everyone who is living in the territory of India will be enjoying that right. Now, when we talk about the Constitution of India, no elaborate provisions with respect to citizenship. And broadly, three things have been said in the Constitution. That is a summary of part 2 of the Constitution. To maintain continuity, you can write. Heading will be Constitutional provisions with respect to citizenship. Constitutional provisions with respect to citizenship. Here you can write the Constitution has no elaborate provisions with respect to citizenship. Full stop. The Constitution from Articles 5 to 11, Constitution from Articles 5 to 11 contains mainly 3 points. First, who at the commencement of the Constitution to be the, और इसको तो हो चुका है दिस, citizen of India. क्योंकि the word, the shall जब लिखा है ना, तो हो चुका, the Constituent Assembly had written shall. So, who on the commencement of the Constitution to be the citizen of India? Two things have been written here: by domicile and by migration. By migration. Domicile has been mentioned in article number 5 and migration has been mentioned in article number 6. So, if we analyze this by domicile, we are talking about 26th of November 1949. That is the date of the, because article 5th came into force from that day only. So who was a citizen of India on that day? Domicile. A person who was residing in India at that point of time. Or if a person whose one or both the parents are born in India. And third, a person who has been living in India 5 years before we can say the commencement of the Constitution. The Anglo-Indians, they come under that category because the Anglo-Indians were living in India 5 years prior to that. They lived in India, they did not go back to their own country. So these are the 3 conditions of domicile. If you wish, you can write it. First, who was born in the territory of India. Who was born in the territory of India. Second, either of whose parents was born in the territory of India and a person who had been ordinarily residing in India for at least 5 years, ordinarily residing in India for at least 5 years before commencement of the Constitution. Before the commencement of the Constitution. So the Anglo-Indians basically come under this category. कौन से? हाँ वही ब्रिटिश इंडिया वाले केस. Now when we say migration तो बहुत easy है, common sensual thing you can apply. What we can write here? Migration. Who will be an Indian citizen by migration? Those who had migrated to India from the territory which is now in Pakistan. So, it's a descriptive questions will not be asked. Just an idea I wanted to give you because minimum knowledge is required. Then, this is the first thing that our Constitution says. Then, secondly, it prohibits dual nationality that is an Indian citizen cannot have the citizenship of another country along with the Indian citizenship. And thirdly, Article 11 authorizes the Parliament. Article 11 authorizes the Parliament to make any provision with respect to with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Because Constitution has no elaborate provisions. It is silent on how a person can become an Indian citizen after the commencement of the Constitution and the other aspects. So that is why Article 11 has authorized the Parliament to make laws. So when the Parliament was authorized by the Constitution, what the Parliament did? The Parliament passed the Citizenship Act 1955, which has been amended from time to time. So you can write it. Accordingly, the Parliament passed the Citizenship Act 1955, which has been amended from time to time. Next, according to the Citizenship Act 1955, as amended in 1986 and 1992, there are 5 modes of acquiring Indian citizenship. By birth, by descent, by registration, by naturalization, and by incorporation of a new territory. By incorporation of a new territory. Details will not be asked. I'll just give you an understanding. By birth, a person born in India and at the time of his or her birth, one or both the parents are Indian citizens. So, born in India. And one or both the parents are Indian citizens. At the time of birth. Here parentage clause is important. It is not only born in India. One or both the parents are Indian citizens. Then only the person will be an Indian citizen by birth. I think most of us are Indian citizens by birth. It has got a Latin nomenclature, jus soli. Law of soil. Law of soil. Then descent. Person born outside India. And one or both the parents Indian citizens at the time of birth. It has got a Latin nomenclature, jus sanguine. Jus sanguine is law of blood. Law of blood. So it is to protect the interest of the Indians who are born outside India. Law, that is just sanguine, sanguine, sanguine. Then certain categories of people can apply for Indian citizenship by registration, like the persons of Indian origin, PIOs, then person married to Indian citizen, and thirdly, minor children of Indian parents. Minor children of Indian parents. Now here, these categories of people will have to fulfill the residential qualification of living in India for 5 consecutive years. 5 consecutive years will not mean 365 days, pura ke, 90 days per calendar year. So, if these categories of people fulfill that residential qualification, they can apply for Indian citizenship. And anyone not falling under categories 1, 2 and 3 can apply for Indian citizenship by naturalization. Means anyone in the globe, means in the world, can apply. Those who will not be falling into these 3 categories can apply for Indian citizenship by naturalization. They will have to live in India for 12 years. That is the condition for naturalization. Then only they can apply for the citizenship of India. And here, by incorporation of a new territory, when a new territory is acquired, its people are offered Indian citizenship. If they accept it, then the government of India is bound to give them citizenship. But if they will not accept it, then the government of India will not be giving them citizenship. For example, when Puducherry became a part of India, its people were offered Indian citizenship. Many of them did not accept the Indian citizenship. So we did not give them Indian citizenship. When Sikkim became a part of India, the citizenship was offered to all the people of Sikkim, and all of them accepted Indian citizenship, and it was given to all of them. We have an agreement in, we can say, Puducherry with respect to the French citizen, and the French government gives economic benefits to the French citizens who live in the diaspora. And you all know that vitamin M is the most important vitamin. So, in order to get that vitamin M from France, they did not accept the Indian citizenship. They vote even today. And they have got representative in the French Senate for the overseas citizens. So, the overseas citizens of France who are living outside, they vote to elect their representative in the Senate so that their rights will be protected. कुछ पूछ रहे? हाँ, अगर इनफैक्ट अगर आप किसी को गोद लेते हो वहां से, ठीक है, अगर आपका बच्चा छोटा है, then obviously you can go for registration. Now here there is a rule for citizenship by descent. If a kid is born, if a child is born, then within 2 years he has to be registered in the Indian embassy. उतना डिटेल नहीं पूछते एग्जाम में, that is why I did not tell you. So his name has to be registered in the Indian embassy so that the formalities will be completed. This is for your knowledge only, questions will not be asked. बीच में गैप ईयर होगा तो फिर से 12 साल तो then only you can apply. Here, fulfilling the residential qualification of living in India will make a person eligible to apply. Whether to give or not to give citizen is the prerogative of the central government, because citizenship is under the union list. You can only apply. But here, in case of by incorporation of a new territory, if a citizenship is offered and the person accepts the Indian citizenship, the government of India is bound to give Indian citizenship. Our citizenship can also be lost. Renunciation, by termination, and by deprivation. Renunciation, voluntarily surrendering the citizenship of India on acquiring the citizenship of another country. That is, we can say renunciation. बोल दे त्याग कर दिया. Then, if a person, if he acquires the citizenship of another country, but he will not voluntarily surrender the Indian citizenship, and if the government of India comes to know about it, it will be termination. Then, termination and deprivation can seem to be the same thing. To terminate the citizenship of a person, which means you are depriving. But in the Citizenship Act 1955, there has been specific grounds of deprivation which has been mentioned. First, if a person has acquired the certificate of registration or naturalization by fraud or by concealment of facts. It is not for us, the first one. So it is for those who have acquired the Indian citizenship by forging certain documents. So they have acquired the certificate of registration or naturalization by fraud or by concealment of fact. That can be one of the grounds. Second ground, if a person within 5 years of acquiring the Indian citizenship has been convicted for at least 2 years of imprisonment by any court. So conviction for 2 years or more within 5 years of acquiring the citizenship. It is also not for us. Or third, if a person during a war in which India was engaged had illegally communicated with the enemy. It is the highest criminal offense. You have conspired against the country. It is valid for all of us. कल ये नहीं बताना, सर ने नहीं बताया. Yes, it is valid for all of us. Then I am telling you the exact words which have been mentioned in the Citizenship Act. And the fourth one is, if a person has been ordinarily living outside India for 7 years, कितना बताया मैंने? 7 years. And during these 7 years, he was never a student in any educational institution, nor employed under the government of India, or in any organization of which India was a member. You will go to any non-state actors and say, I am working there. It's not like that. Recognized by the government of India or under the government of India. Because your records will be there. That these students are reading here. These people are working in these institutions. So then, or if a person has not shown his intention of coming back to India and to retain his Indian citizenship. Some people go for their personal reasons. Their relatives may be there, or they may have gone for a long treatment. For such person who do not fall in the two categories, that is student category or employment category, they will have to visit the Indian consulate every year, and they will have to fill up a declaration form that I wish to go back to India and retain my Indian citizenship as soon as my obligation is over here. I am residing at this address. If a person has not done it for 7 long years, then this can be a ground of deprivation. Because logically, in some of the countries we have the law that you can become the citizen of that country if you live in that country for 7 years or 5 years. So it may be that you have acquired the citizenship of that country. That is why you have not signed, you are not filling the declaration. ये तो बहुत रेयर पूछते हैं इन द एग्जाम में. Yes, it is only for the continuity I told you, because there is a minimum knowledge that is required. Mechanical नहीं हो चीजें इसीलिए. Now, another thing that you need to know, it is the dual citizenship for the OCI card holders. Some of you may be thinking that the teacher, when he had started the discussion on citizenship, he had said that there is no dual citizenship in India, but now he has written a heading here, dual citizenship for the OCI card holders. You see, it has nothing to do with the technical meaning of the term citizen. It is an economic term. And basically, this concept came in 2003 to woo the investments in India. Because before that, no concrete efforts were taken, as there was political instability going on in the country. The prime ministers used to come and go. And when Sri Atal Bihari Vajpayee became the prime minister for the 3rd term, he was the Indian prime minister first for 13 days, 13 months, and then for the 3rd term when he came. And when he was confident that he will complete the full term, then he started thinking about economic development. How to woo the investor was a big challenge. That is why the process started with wooing the persons of Indian origin. Who are the persons of Indian origin? Their ancestors were Indians, and many PIOs were doing well in the economic field in the world. So there was an emotional touch with them. So that is why the government of India felt that we should owe them. And that is why this concept of dual citizenship came. इसीलिए फिर हुआ प्रवासी दिवस सम्मेलन, फिर the concept of this dual citizenship came. So it started in 2003. Some facts you can write here. The Citizenship Amendment Act 2003 provided for dual citizenship for the PIOs living in 16 countries. That was when Vajpayee ji was there, and a person who wished to acquire the dual citizenship of India, there is a PIOs of 16 countries, they had to buy a PIO card paying 100 US dollars. I am talking about that time in 2003. Means you'll have to purchase the dual citizenship of India, and they were given some economic rights. Come to India without visa, invest directly in projects in India, buy property in India except agriculture land and we can say the farmlands, but no political rights to them. When Dr. Manmohan Singh became the Prime Minister, there was demand from the OCIs, Overseas Citizens of India. The difference between PIOs and OCIs, PIOs, their ancestors had settled abroad generations back. You may have heard the name of some West Indian cricketers. क्या नाम है जो इंडियन नाम जैसा है? सुनील नारायण, हाँ, ये सब चंद्रपाल, ये सब Indians. So persons of Indian origin. Not only this, the persons of Indian origin are settled in Mauritius and they are holding the post, we can say they have become the parliamentarians there. And Sir Shivsagar Ram Gulam was a person of Indian origin. If you go to Patna, he hailed from Bihar. There is a statue of Sir Shivsagar Ram Gulam near the exhibition road, that is near Gandhi Maidan. So PIOs, persons of Indian origin. OCIs, OCIs are those who have settled abroad, but their family members may still be living in India. Their parents, their brothers, their sisters may still be living in India, OCIs. So that group of people started requesting for the dual citizenship. So an amendment was made here. Second point you can write, the Citizenship Amendment Act 2005 provided for dual citizenship for the PIOs and the OCIs across the globe. PIOs and OCIs across the globe. Means the 16 countries cap was removed. Anyone can apply. So there were two cards, PIO card and OCI card. When Sri Narendra Modi became the Prime Minister of India, these cards were merged. The PIO card scheme was withdrawn and it has been merged with the OCI card scheme. लिख लो इसको भी. In 2015, the PIO card scheme was merged with the OCI card scheme. So now there is only one term. Ab wo PIO term is also not there officially. The definition is that of OCI card holder. In the Citizenship Act, it is OCI card holder. So what are the rights of an OCI card holder? An OCI card holder can come to India without visa. In bracket you can write multiple entries. Then secondly, he can buy property in India. Except agricultural land and farmland. Farmland is the area where the cattle graze, charagah bolte hain. Then they can invest directly in projects in India. but they have no political rights. They have no political rights and cannot hold office in defense services. So they can be consulted in the civil jobs, but they cannot be even consultants in the defense services. Then क्या था, वो तो कुछ दे के आएंगे ना, तुमसे लेके थोड़ी ना जा रहे हैं, कहा वो तुम्हें देंगे, इंडस्ट्री बनाएंगे यहाँ पे, गरीब लोग थोड़ी ना आएंगे। हाँ, गरीब नहीं आएंगे, अमीर लोग आएंगे। हाँ, वो पैसा देके खरीदेंगे ना सिटीजनशिप तुम्हारे, तो एक तो तुमको डॉलर्स देंगे, ठीक, हाँ, हम तो रुपए में रह रहे हैं और डॉलर का वैल्यू पता ही होगा, देख लेना। और नॉट ओनली दिस, आपके बैंक्स में पैसा रखेंगे, क्यों, उनकी कंपनी यहाँ पे रहेगी, तो आपके बैंक वाले उससे वो क्या करेंगे, उस पैसे को अपने पास से लोन भी देंगे दूसरे को, ये सब भी तो फायदा होगा। आप कुछ जो, आप, इंडिया बहुत बड़ा देश है, दयालु है वो, हाँ, वो, और ये सब नहीं समझो, वो फायदा भी देखता है, ये चीज है। नाउ हियर यू कैन राइट एज नोट, द सिटीजन्स ऑफ पाकिस्तान, the citizens of Pakistan, Bangladesh, and any other country, as may be notified by the government of India, from time to time, cannot apply for the dual citizenship of India. Cannot apply for the dual citizenship of India. Now, if we talk about Pakistan and Bangladesh, everyone will be a PIO, or yes, everyone will be. तो वो भी नहीं पॉसिबल है, वो भी मैंने आपको बोला कि हाँ, यू नीड टू, ऐसे थोड़े ना होता है कि, तो there is a, so here Pakistan, it is written in the act only that the citizens of Pakistan and Bangladesh cannot apply, and any other country as notified by India, taking into consideration of our national interest, the decision can be made by the government of India in this regard. Then there is another Citizenship Amendment Act which has again been in the news, and that is the Citizenship Amendment Act 2019. Citizenship Amendment Act 2019. You all may have heard about this act. It was not asked in any of the, it has not been asked in any of the examination till date. But again, the issue is there with respect to the implementation of this Citizenship Amendment Act 2019. So some basic things may be asked in the examination. You can write it. The act seeks to give fast track citizenship to the Hindus, Sikhs, Buddhists, Jains, Christians, and Parsis who have illegally migrated who have illegally migrated to India from Pakistan, Bangladesh, and Afghanistan. Full stop. The cutoff date was kept as 31st December 2014. Means a person belonging to these communities who have come to India before this date, that is 31st December 2014, can be eligible for the fast track citizenship of India. What is this fast track citizenship? They will be given citizenship within 6 years. 6 years. Normally under naturalization it is 12 years, but they will be given citizenship within 6 years. ये चीज है, तो यही एक लॉजिक है यहाँ पे. There has been lot of hue and cry here and there. The matter had gone to the Supreme Court also, but the Supreme Court denied to put a stay on the Citizenship Act. The Citizenship Act has been passed by the Parliament way back in 2019, but it has not been implemented yet. The reason being that after a law is made by the Parliament, the rules and procedures have to be prescribed by the Government of India. That is how this particular law will be implemented. So as that rules and procedures were not prescribed by the Government of India, that is why it was not implemented. But again, it was in the news last month only and this month, when our Home Minister said that before the elections we are going to implement the Citizenship Amendment Act 2019. That is why it was in the news. So which of the following communities are covered under the Citizenship Amendment Act 2019? Such type of questions may be there in the examination. So these were the things that we needed to discuss, especially from the prelims point of view, in part 1 and part 2. These are B grade topics, means just you need to see and just you need to go. Then the topic which is more important for us, that is part 3rd of the Constitution, we'll be starting it in our next session. We'll stop here for a brief break of 30 minutes. For our online students, we were on a break. So we started the session a minute back and we had started our discussion on the fundamental rights. And therein we had introduced the concept of rights, and we had discussed that rights are the claims of an individual on an authority. Rights are not privileges, they are the claims, they are the legal things. And this is the legal dimension of rights. This is the moral dimension of rights. That rights are those conditions of social life without which no individual can be at his or her best self. So the summary is, rights are needed for the development of an individual's personality. Such type of statements may be there in your examination. Now, going to the roots of the fundamental rights, the roots are there in the concept of human rights, because human rights are considered as basic rights. You see, there are two words here, man and human. Man is a biological animal. And when we say human, it is a sociological entity. Suppose if you throw a food towards an animal, that animal will have that food. It will not ask, the doggy will not ask you that please you should treat me well, never. You throw a chapati towards a cow and the cow will have that. But suppose if someone will throw a chapati at you, hey, have it. Or even if you are given a packet of biscuit, hey, have it. What do you say? Hey, please treat me like a human being. I am not a doggy or I am not an animal. So basically, what you want? You want a dignified life. You want to be treated with dignity. That is the concept of human rights. That is not to be treated like a biological animal, like a sociological entity. Now here, so going by the easiest definition, the simplest definition of human rights are those rights which are considered essential for a dignified human existence. A dignified human existence. Now, going by the roots of the human rights have its roots in the theory of natural rights. And the classical liberals, especially if we talk about the English philosopher John Locke talked about the concept of natural rights. And John Locke talked about three natural rights: right to life, right to liberty, and right to property. These rights basically were considered as natural rights, and it was held that these rights have not been given to an individual by any state or by any individual. These rights were considered as absolute rights. So it was held that these rights are there with the individuals because they are born as human beings. No individual, no state has given these rights to them, and that is why no one has the right to take back these rights from the individual. The state has recognized these rights. The state has not given these rights. These rights were also considered as inalienable rights. Inalienable rights. Now, the argument that was put forward here was that you cannot alienate a tree from its rights to have flowers, leaves, and fruit without ending its existence. You cannot. Similarly, these rights are inalienable. You cannot take these rights from an individual until and unless you will not end the existence of that particular individual. So, the concept of human rights has its roots in the theory of the natural rights. No theories of human right was evolved as such. But the concern of human rights was felt during the Second World War. Two incidents had taken place. One, the mass killing of the Jews by the forces of Hitler, and secondly, the atom bomb on Hiroshima and Nagasaki. It shattered the humanity at large, and the world community started thinking that if the human beings are to be treated like animals, that is why after the Second World War, the efforts were taken to stop the future wars, and the United Nations organization was created. The Charter of the UN says that its objective was to stop the future wars. But as far as the understanding goes, it wants to protect, it aims to protect the human rights of the people across the globe. Why? Because war is the greatest violation of human rights. War leads to loss of life, loss of property. People become refugees, children become orphans, women become widows. What else we want? So, and as the organization talks about stopping the future wars, we can say that the objective of the United Nations was to protect the human rights of the people. But in the Charter of the United Nations, there was no, we can say, description of the human rights of the people. The efforts continued, and it was on 10th December 1948 that the world community, it adopted the Universal Declaration of Human Rights. And in that document, UDHR, the human rights of the people across the globe has been mentioned. Those human rights which have been included in the Indian Constitution under Part 3rd, they have been termed as fundamental rights. So some points you can write here. The UN General Assembly, adopted the Universal Declaration of Human Rights on 10th December 1948. This day is observed as International Human Rights Day. International Human Rights Day. The UDHR is the source of human rights in the world. Is the source of human rights in the world. Even in the interviews, if you are asked this question, that which document or what is the source of human rights in the world, the answer will be Universal Declaration of Human Rights, because it is the document where the human rights have been codified. It consists of a preamble, and 30 articles. Now what you can do is that you can Google Universal Declaration of Human Rights, and there is an official website of the UDHR, udhr.org. So you can just have a glance that what are your human rights, so that in examination, if the question is which one of the following is a human right, so you will have an idea that okay, these are our human rights. Questions may be expected in the examination. Then next point you can write, these human rights are not binding on the countries, but it is expected that a democratic country should incorporate as many human rights as it can in its law. Full stop. Those human rights which have been incorporated in part 3rd of the Indian Constitution, are termed as fundamental rights. Full stop. Here you can write as note, NOTE. The preamble and part 4 of the Constitution, that is directive principles of state policy, also contain the human rights. So in the prelims examination, such statements will be there or question will be there. that in which part of the Constitution the human rights have been mentioned. So part third, then preamble, because preamble says equality of status and of opportunity, then liberty of thought, expression, belief, faith and worship. These are our human rights. So in the preamble also the human rights have been mentioned. Then in the directive principles of state policy, equal pay for equal work for both men and women, right to work, human conditions of work, leisure, these are the directive principles of state policy. So such questions and we have not incorporated all the human rights also, but yes, now in this year prelims examination there can be a question, which of the following is of human right? Right to marry and have a family is a human right, but it is not a fundamental right. Earlier, 2 years earlier, the Supreme Court had said that it is a fundamental right, but there was lot of confusion and people went to the court for same-sex marriage. Then court said right to marriage is not a fundamental right under Article 21. So 2 साल तक we taught that. अब इस साल से we will not be teaching that, because the Supreme Court judgment is right to marriage is not a part of the Article 21. It is not a fundamental right. Earlier it was termed as an inferred right. Now, this was a brief introduction. From here the questions can be, which one of the following is a human right, and then which parts of the Constitution contain the human rights. Now coming to the next aspect, nature of fundamental rights. First of all, the fundamental rights are enforceable or justiciable. Everyone who is preparing for any examination in the country knows it, that if the fundamental rights are violated, one can go to the court, including the highest court of the country, that is the Supreme Court. The fundamental rights are negative obligations, on the part of the state as most of the fundamental rights are negatively worded. I have not written they are negative rights, negative obligations on the part of the state, as most of the fundamental rights are negatively worded. You see, when we say obligations, positive obligations and negative obligations, it is all about words. If I say, please maintain silence in the class, it is your positive obligation. What you will say amongst yourself? Let us be silent in the class. Let us be silent in the class. So then if I say don't disturb the class, it is negative obligation. We should not disturb the class. We should not. Similarly, if you talk about the words which have been used in the fundamental rights, most of them are negatively worded. The state shall not discriminate. What the state shall not do? So the state shall not discriminate. What the state is not supposed to do. So most of the fundamental rights, they are negatively worded. That is why negative obligations. Then these are not absolute, but restricted rights. Why? Because unrestricted freedom may lead to chaos and anarchy. Freedoms cannot be absolute. And when we talk about freedom, it is said, my liberty to extend my arms ends where the other person's nose begins. My liberty to extend my arms ends where the other person's nose begins. Freedoms cannot be absolute. And that is why there can be reasonable restrictions on the fundamental rights. So, अगर लोग समझते हैं ना कि fundamental rights है, absolute है, it is not like that. And only some of your fundamental rights are there which are absolute one. There can be no restrictions on them. Even your right to life, right to personal liberty is not absolute. The court will say hang till death, and your right to life will be taken. Then shoot at sight orders are given, your right to life can be taken. So what our constitution says, no one to be deprived of his right to life and personal liberty except according to the procedure established by law. Means it is not absolute, it can be taken. Then even some people say that right to religion is absolute. But the first sentence in Article 25 is subject to public order, morality and health. Subject to. It means there can be restrictions on these grounds. But some of the fundamental rights, they are absolute in nature. But before that, what can be the general grounds of reasonable restrictions on the fundamental rights? First, in the interests of the sovereignty and integrity of India, then in the interest of security of the country, then in the interest of the weaker sections of the society, weaker sections will include children, women, scheduled castes, scheduled tribes, people with disability. Then to maintain public order, decency and morality, then contempt of court, and defamation. Defamation is character assassination, मानहानि बोलते हैं. So these are the general grounds. Specific grounds are also there on which the fundamental rights can be taken. That I will be telling you when I will be discussing with you the specific fundamental rights. That this right can be restricted on these grounds. So in the MCQs, if the question is asked, only those aspects have to be written. It is a general one. So if a general question is asked that on which of the following grounds there can be reasonable restrictions on the fundamental rights. So these are the general grounds. I had said that some of the fundamental rights are absolute rights. Means there can be no restrictions on them under any circumstance. They are known as absolute rights. Absolute fundamental rights. First, right against untouchability. Article 17. Right to education. Article 21A. Then prohibition of employment of children below 14 years of age in hazardous occupations. Article 24. Under no circumstances a child below the age of 14 years will be employed in mines or factories or any other hazardous occupation. Under no circumstance you are supposed to practice untouchability. Untouchability has not been defined in the Constitution or any statute. It is a typical practice of the Hindu social order, that is to socially exclude certain sections of the society, untouchability. So it has not to circumstance. And if a child from 6 to 14 years of age wishes to take admission in the school, he should not be denied in a government school. So all your fundamental rights, they have got buts. Then when we talk about the topic of fundamental rights, in this topic, fundamental rights as well as in the directive principles of state policy, the word state has been used. The state shall not discriminate, the state shall not deny, or the state shall strive in part 4. So combinedly here I will tell you a smart work we will be doing, that what will be the meaning of the term state in part 3rd as well as in part 4. Definition of state. This definition of state has been mentioned in article number 12 of the Constitution. So here you can write article 12. Article 12 has defined the state, for the purpose of Part 3rd of the Constitution. Full stop. The expression state includes the government and Parliament of India, the government and Parliament of India, the government and legislature of each state, means your state council of ministers as well as your state legislature, and thirdly, all local or other authority within the control of or within the territory of India, we can write, or within other authority within the territory of India, or under the control of the government of India. So, means any government authority from the President of India till the PN of a Panchayati Raj institution in his official capacity will be considered as the state. Now, a basic question that is asked, generally asked, is whether the judiciary will come under authority or not, because you see here the word authority is there. So, where the judiciary will come under the definition of the state or not. Here, when the judiciary discharges its judicial functions, then it will not come under the definition of state, because you see the government of India takes the decision. It is challenged in the Supreme Court. It is versus Union of India. So here the judiciary will not be a state. It is fighting a case. It is looking into a case against the government of India, against the state. Then the parliament passes a law. For example, you see the Chief Election Commissioner and the Election Commissioner Services Act has been passed. So it has been challenged in the Supreme Court. So here it is looking into an act passed by the Parliament of India. So in this case, here the judiciary will not be a part of the state. But while discharging its administrative functions, the judiciary will be a state. For example, there are officers in the Supreme Court, like the registrar. There are other officials and servants, we call them, like the stenographers and many other officers are there. If any injustice is done to them, legal injustice in promotion, or we can say in the recruitment process, the case can be filed against the judiciary itself. So, while discharging the administrative functions, for example, the employees who are working in the Supreme Court, if they have any problems with respect to promotion, they can go to the court against the Supreme Court itself or against the High Court itself, that injustice is being done. So, at that point of time, there the judiciary will not be the state. So, while discharging the judicial function, it will not be the state. While discharging the administrative functions, it will be part of the state. It will come under this authority. So, if students get confused, sir, whether judiciary will come under the state or not, because it is not mentioned here. Government of India and Parliament of India. the government and legislature of each state. And here the word is authority. So in a layman's term, the government of, and not only this, what is we have written? Under the control of the government of India. Even if a government of India enterprise is working outside India, we have the Indian embassies, we have ONGC Videsh. So they will also come under the definition of the state, because they are working under the control of the government of India. All the PSUs, they will come under the definition of government of India, or we can say the state. So आप क्वेश्चन कैसे प्रैक्टिस करोगे? नेचर ऑफ फंडामेंटल राइट्स, वन क्वेश्चन. You need to practice like this. Human rights. Oh, what are the questions which have been asked with respect to human rights? What are the questions which have been asked from the nature of fundamental rights? One question. Then judicial review and fundamental rights. Two words are there. One is judicial review, other one is the fundamental right. Judicial review is the power of the judiciary to review a legislative action or a decision of the executive and to declare it as void if it is inconsistent with the provisions of the Constitution or law. Now from here what we deduct is that judicial review is against the legislative action, means a law made by the legislature as well as a decision of the executive. So the general perception is a law made by the parliament, it will be reviewed by the judiciary, it will be termed as a judicial review. No, even if the executive has taken a decision and if it is reviewed by the judiciary, it will be termed as judicial review. For example, if an appointment has been made of a CBI director and that is reviewed by the Supreme Court, it will be judicial review. So such type of questions can be there in the prelims examination, that judicial review is against both we can say a law made by the legislature as well as a decision of the executive. This concept of judicial review, it evolved in the US. It evolved in the US. And it was in 1803 in the Marbury versus Madison case. In the Marbury versus Madison case. Now what had happened, that in 1789 the US Congress had passed the Judicial Act, and it was challenged in the Supreme Court. And in the Marbury versus Madison case 1803, the Judicial Act, which was passed by the US Congress, was declared as null and void. So it is not mentioned in the US Constitution, but it is started in the United States of America. That is what we have written. It evolved in the US. And pronouncing the judgment, the Chief Justice of the US Supreme Court, Justice Marshall, had said that the US Constitution was the highest law of the land, and IFA, which has defined the powers of all the organs of the government. And if any law of the Congress will be against the Constitution, then the judiciary has every right, every power to declare it as null and void. So from there, the concept of judicial review evolved. Next, you can write here, in case of India, the power of judicial review lies with the Supreme Court as well as the high courts. Common sensual questions are asked from judicial review. Which of the following statement is correct regarding judicial review? Supreme Court has the power to review the laws and the actions of the union government, parliament, as well as of the state governments also, and the state legislatures also. Whereas the high courts have the power of judicial review over only the decisions of the state government and the state legislatures. It cannot look into the validity of a law made by the parliament or a decision taken by the union executive. Now coming to the second part of it, ये तो था आपका basics, judicial review and fundamental rights. If a law violates any of the fundamental rights, if it is to be declared as null and void, here we have got two doctrines that we need to understand. One, the doctrine of severability. Here we need to understand two articles of the Constitution. Article 13 clause 1 and Article 13 clause 2. They are termed as doctrine of severability. ये सब अपने ना मदर टंग में याद रखना, मैं समझा दूंगा धीरे धीरे. You need to understand it in your mother tongue. Never try to mug up Article 13 clause 1. I have also not mugged up. I have got the understanding of it. Now coming to the summary of Article 13 clause 1, you can write here. Article 13 clause 1 holds that all laws enforced in the territory of India immediately before the commencement of the Constitution, comma, insofar as they are inconsistent with the fundamental rights, comma, to be declared void, 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 to the extent of such inconsistency, void to the extent of such inconsistency. Now, here you need to underline two sentences. First, before the commencement of the constitution. आपने बीच में लिखा ना, Article 31 holds that. There you see, you have written before the commencement of the constitution. Underline it. And then lastly, what we have written? Declared void to the extent of such inconsistency. Underline it. To the extent of such inconsistency. In bracket you write pre-constitutional laws. Pre-constitutional laws. I'll explain it. अभी मैं सब समझा दूंगा आपको कि once you go outside this room, everything should be there in your mind. Now coming to article number 13 clause 2. इसकी summary write it. Then I'll explain both of the articles together. अभी तो just मैंने बताया ना. High Court cannot. You can, the power is there with the Supreme Court. Parliamentary law can be challenged in the Supreme Court. Delhi High Court, no. Delhi High Court can look into the disputes that can arise. Jैसे if the government of NCT has got some complaint with respect to the powers which has been mentioned, that is constitutional cases can be referred with the interpretation of Article 239A. Then the government of NCT had gone to Delhi. But if a law has been made, for example, the government of NCT Amendment Act has been passed, 2023. It can be challenged in the Supreme Court, not in the Delhi High Court. Article 13 clause 2 holds that the state not to make any law which takes away or abridges the fundamental rights and any law made in contravention to the or contravention of this clause to be void VOID, void to the extent of such contravention, underline, to the extent of such contravention. In bracket you can write post constitutional laws. Now, when we say pre-constitutional law, Article 13 clause 1 is talking about the laws which were there before the commencement of the constitution, that is the 26th of January 1950. They were applicable. And Article 13 clause 2 is talking about post-constitutional law. Here many British laws will also come. For example, the Muslim personal law. It is an example of a pre-constitutional law. This law existed before the commencement of the constitution. So here we are talking about the pre-constitutional laws. Then, because many pre-constitutional laws are existing even today. and post-constitutional, not what we have written. It will take 2 minutes and you will be able to understand it. Suppose law A. Law A may be a pre-constitutional law or a post-constitutional. Means it may be there before the commencement of the constitution or it has been enacted after the commencement of the constitution. That is after 26th of January 1950. Suppose law A has got some clauses. Suppose if there is an fundamental right, say article number 23. It is a hypothetical situation. Now, if clauses C and D of law A, they are implemented, they will violate article 23 of the constitution. A, B and E, if they are implemented, they will not be violating any of the fundamental rights. But suppose clauses C and D, they are implemented, then they will violate article number 23. Then what we have written, I have made you to underline the last sentences. To the extent of such inconsistency. So a law, whether it is a pre-constitutional or a post-constitutional law, if it violates any of the fundamental rights, to be declared as null and void to the extent of such inconsistency. Means the whole law will not be declared as null and void. Only the clauses or the sub-clauses which are coming in conflict with the fundamental rights, only they will be declared as null and void. So what we have got? ऐसे imagine करना, अच्छा, a law has been made by the parliament or a law is there which is existing before the commencement of the constitution. It violates the some of its clauses have violated the fundamental rights. So only those clauses will be declared as null and void. In your mother tongue, you need to remember it. Because in the prelims examination, there are 4 options. It is not that you have mugged up all the things. You have whether you have understood it or not. So a law, the whole law will not be declared as null and void. Only the clauses or the sub-clauses which are coming in conflict with the fundamental rights, they will be declared as null and void. This is the doctrine of severability. We are severing the ties. हमने इससे रिश्ता खत्म कर लिया. Why? Because these 2 clauses were coming in conflict with the fundamental. समझ लोग इसको समझते this is a rocket science. It is nothing. So the complete law will not be declared as null and void. ये चीज. So doctrine of severability associated with the fundamental rights. Up. Supreme Court is the final interpreter of the constitution. A gentleman called Bhikaji Narayan, he went to the Supreme Court and I was not audible to the online students for 1 or 2 minutes. So I will just recap for you. What we were discussing was that a law, that is doctrine of severability, a law, if it violates any of the fundamental rights, the law will not be declared as, the complete law will not be declared as null and void. Only the clauses or the sub clauses which are coming in conflict with the fundamental rights, they are to be declared as null and void. But a gentleman went to the Supreme Court, Vikaji Narayan, for the interpretation of article, this doctrine of severability, and he pleaded that such a law may not be declared completely as null and void. It asked the Supreme Court to suggest that what is the way out. Then the Supreme Court in the Vikaji Narayan case gave the doctrine of eclipse. Doctrine of eclipse. What is this doctrine of eclipse? Something is written on the board, and suppose if I stand here, what is written in the board, on the board, may not be visible to all of you. Why it is not visible to all of you? Because I am in between you and the board. If I am here, this part will be visible to you again. The Supreme Court said that a law, even if it is violating any of the fundamental right, it may not be declared as a dead law altogether. It may not. It completely depends on the court, that is the Supreme Court. It may apply the doctrine of severability, it may apply the doctrine of eclipse. So the law may not be declared as null and void, but it will be overshadowed by the fundamental right. Means it will be there in the law book. In the doctrine of eclipse, it will be declared as a dead law altogether. It will be dead law. It will not be there in the rule books. Doctrine of eclipse, let it be there in the law book, but it will not be implemented. Why it will not be implemented? Because it is inconsistent with the fundamental right. Suppose in the future, there is an amendment in the fundamental right, and these clauses obviously will not be coming in conflict because there is an amendment here, then these clauses will be implemented. So doctrine of eclipse, that is overshadowing. But it completely depends on the court whether to use the doctrine of eclipse or the doctrine of severability. So doctrine of eclipse, you may write, the Supreme Court in the Vikaji Narayan case, the Supreme Court in the Vikaji Narayan case gave the doctrine of eclipse. The court held that a law, even if it is inconsistent, with any of the fundamental rights, may not be a dead law altogether, or may not be declared as a dead law altogether. It will be overshadowed by the fundamental right. Full stop. The eclipsed part gets revived and effective again if the prohibition brought about by the fundamental right, is removed by an amendment to the Constitution. Full stop. The Supreme Court in the Sri Ambika Mills case, there is no need to mug up Sri Ambika Mills versus State of Gujarat case 1978. It hardly matters. So the Supreme Court in the Sri Ambika Mills case held that the doctrine of eclipse to be applicable for pre as well as post constitutional laws. So which of the following statement is correct regarding the doctrine of eclipse? So the doctrine of eclipse was propounded in the Bikaji Narayan case. That is the correct statement. Then second statement may be the doctrine of eclipse is applicable in case of pre-constitutional laws only, then post-constitutional laws only, and in case of pre as well as post-constitutional laws. So 1 and 4, 2 are correct. Such type of questions may be there. Bikaji Narayan case was related only with the pre-constitutional laws. So that is why in the Sri Ambika Mills case there was a justification that it will be valid for the post-constitutional laws. क्या समझा आप लोगों ने? What you understood? A law will be declared as null and void. All the, we can say, clauses will be declared as null and void, or only those which are inconsistent. So in mother tongue you should. And what is doctrine of eclipse? The law may not be declared completely as null and void. It will be overshadowed by the fundamental. What happens in the eclipse? Overshadowed हो जाता है. So that will happen here also. So judicial review, doctrine of eclipse, doctrine of severability, one question. ये पोस्ट कॉन्स्टिट्यूशन, बस यही डिफरेंस नहीं और कोई डिफरेंस. Now coming to another question. Suspension of fundamental rights. Means under what circumstances our fundamental rights can be suspended. Two articles are here. Only for the reference I am telling you the number of articles. You are not supposed to monitor. Now what is mentioned in article 358? It is under article. Means what is mentioned in article 358? Article 90, sorry. The fundamental rights under article 19 to be automatically suspended if the national emergency is proclaimed on the grounds of war or external aggression. Or external aggression. See, we'll be discussing national emergency in detail in one of the classes. And when we talk about the national emergency, many of you may be knowing that the national emergency can be proclaimed on three grounds: war, external aggression, or armed rebellion. Suppose if today the president proclaims the national emergency on the grounds of armed rebellion, that there has been armed rebellion in some of the states in North India, the national emergency is being proclaimed in this part or in the country as a whole, then our fundamental rights under Article 19, the 6 democratic freedoms, will not be suspended. They will be there with us. But suppose if the president proclaims the national emergency on the grounds of war, that we are at war with this country, or this country has attacked India, there is an external aggression, and national emergency is being proclaimed. As soon as the president will sign the proclamation, the 6 democratic freedoms under Article 19 will be automatically suspended. That is what we have written. So if the examination there is a statement that the fundamental rights under Article 19 are automatically suspended during the proclamation of national emergency, it will be a correct statement or not? No, it will be a wrong statement, because only on these two cases. Because when we say national emergency, it will include internal, we can say armed rebellion also. What about the other rights? The other rights will be there with you, but they can be suspended by another proclamation of the president. So there will be another proclamation that these fundamental rights are being suspended. It is mentioned in Article 359. Under Article 359, the president, by a separate proclamation, can suspend all the fundamental rights except those under Articles 20 and 21. Articles 20 and 21 cannot be suspended. This aspect was not there in the original constitution. In the original Article 355, it was mentioned that the president by a separate proclamation can suspend all the fundamental rights. But this particular clause was added by the 44th Amendment Act, 1978. Again, I tell you this when I will be discussing emergency provisions with you. Because in 1975, when the national emergency was proclaimed, at that point of time, right to life, right to personal liberty, and then arbitrary arrests were made. That is why when the Janata Party government came to power, it amended Article 359. So which of the fundamental rights cannot be suspended even during national emergency? Those under Articles 20 and 21. and Article 19 will not be automatically suspended when the national emergency is proclaimed on the grounds of armed rebellion. So this is the summary. So one question from here you need to practice like this. Another area from where the UPSC is very fond of asking questions in the examination is the amenability of the fundamental rights. Under it, we are going to discuss that if the parliament has the power to amend the fundamental rights, there is no yes or no answer to it. First of all, you see what is mentioned in the Constitution. Article 13, Clause 2. The state not to make a law which takes away or abridges the fundamental rights. So, the parliament or the state cannot make a law which takes away or abridges the fundamental rights. Otherwise, it is to be declared as null and void to the extent of such contravention. Now, there is no need to write it again. We have written it. What happened? I'll tell you a big background of it. Otherwise, the things will be very mechanical for you. You see, the first Amendment Act was passed in 1951. ये आप लिख लो, you can write it. The first Amendment Act, 1951, added Articles 13, Clause 4. Sorry, added Article 15, Clause 4 and 31B and the 9th schedule in the Constitution. So, 2 articles were added and 1 schedule was added by the First Amendment Act 1951. What was the subject matter of Article 15, Clause 4? Article 15, Clause 4 authorizes the state to make special provisions for the socially and educationally backward classes of citizens, including the scheduled castes and scheduled tribes. So, in the original Constitution, nothing was mentioned, and in Article 15, Clause 4, a new article was added, and the state was authorized to make laws for the socially and educationally backward classes, including scheduled castes and scheduled tribes. Then, when we talk about the 9th schedule, Coming to this 9th schedule, then I will coming to Article 31B. In the 9th schedule, the 9th schedule was added, and what was there in the 9th schedule? It contained the social legislations including the Land Reform Acts passed by the Parliament as well as the state legislatures. As well as the state legislatures. So in the 9th schedule, social legislations were to be incorporated, and that will include the Land Reform Acts passed by both the Parliament as well as state legislature. Now, what was written in Article 31B? In Article 31B, it was mentioned that a law or a matter mentioned or incorporated in the 9th schedule not to be subject of judicial review. Not to be the subject of judicial review. I just wanted to give you an idea because I don't know, some of you may have read, some of you may not have read. May not have done your classes for even the GS portion. So generally the students, they mug up the cases, then they feel that, oh, they know everything. But that is half the knowledge. Why the cases started coming to the Supreme Court? We will have to understand this background. The 9th schedule was added. And in the 9th schedule, what we have written, social legislations, means the social laws which were passed by the state and parliament were added. Suppose Bihar passed the Bihar Land Reforms Act. It was approved by the parliament and added in the 9th schedule. That Bihar Land Reform Act is a subject in the 9th schedule. Then Bengal Land Reforms, West Bengal Land Reforms Act, added in the 9th schedule. So, and it was mentioned in Article 31B that a law which has been incorporated here or mentioned under the 9th schedule will not be challenged in the Supreme Court, is not subject to judicial review. And when the Land Reform Acts were passed by the states and they were approved by the parliament and added in the 9th schedule, this Land Reform Act is a subject of the 9th schedule now. You cannot challenge that Land Reform Act in the Supreme Court. And what had happened to the Land Reform Acts? Jamindari was abolished. Land is a subject in the state list. So just after independence, the state needed land for the infrastructure purpose, for offices, for educational institutions, for national highways, for industries. Land was needed. And it was private ownership of land. The British, they had given the land to the Jamindars. It was there with the Jamindars. So the states basically, they started passing the Land Reform Acts that a person cannot keep more than this much of land. Generally, you are taught in the class or there is book, the First Amendment Act abolished Jamindari. How it abolished Jamindari? The 9th schedule was added and Article 31B, and in the 9th schedule, such laws passed by the states after approved by the parliament has to be mentioned here. And the laws which are mentioned here cannot be challenged in the court of law. At that point of time, right to property was a fundamental right. So when you are abolishing Jamindari, you cannot even go to the court of law. It was against Article 31, that is right to property. And this amendment was against right to equality. Because Article 15 clause 1 says, that is, the state shall not discriminate against the citizens only on the certain grounds, place of birth, religion, caste, race, sex. But here what you are saying, the state can make a special provisions for the socially and educationally backward classes. It violated Article 15 clause 1 of the Constitution, right to equality, and it violated right to property, because you are abolishing Jamindari. क्योंकि आप तो कोर्ट भी नहीं जा सकते हो ना, तो Jamindari abolished. So in this way the First Amendment Act abolished Jamindari, and this is the background that you require to know. नहीं तो वो तो मैकेनिकल किताब में लिखा हुआ है, शंकरी प्रसाद केस, गोलकनाथ केस, रट लिए. But why the cases went to the court? Why Shankari Prasad went to the court? Shankari Prasad went to the court. He was a Jamindar. He went to the court against the First Amendment. So from here, the cases started going to the court, that whether the parliament has the power to amend the fundamental rights or not, because it was claimed that it violated Article 13 clause 2. Now let us see the cases. कॉन्टेक्स्ट समझ में आ गया ना? क्योंकि देखो प्रीलिम्स में भी देना है, इसका ये मतलब नहीं कि सिर्फ केस रट लो, क्योंकि क्या होता है ना, लॉन्ग में यू विल नॉट बी एबल टू रिमेंबर द थिंग्स. अभी अच्छा, why we are discussing it, parliament? Because the first act was passed and Article 15 clause 4 was added, and it holds that the state can make a special provisions for scheduled caste, scheduled tribes and other socially and educationally backward classes. So it violated right to equality, which was a fundamental right. Then Schedule 9 was added. उसमें ऐसे imagine करना है, Land Reform Acts passed by the states. It made provision that okay, if a person has got this much of land, then it will be taken over by the state. And it was added in the 9th schedule, and Article 31B says that if a matter is added in the 9th schedule, you cannot challenge it in the Supreme Court. It is not subject to judicial review. So Jamindari was abolished, because you cannot keep land more than this much. You need to have such an idea. So in light of that, it was challenged. So in the next sentence you can write for your continuity, thus the First Amendment Act violated right to equality and right to property, which was a fundamental right at that point of time. Now you are getting the things. So such type of understanding has to be developed. The things will be very easy for you. Up, going to the court. In the Shankari Prasad versus Union of India case, 1951, the Supreme Court held that the Parliament has the power to amend the fundamental rights. Has the power to amend the fundamental rights. कुछ बोल रहे थे आप? So here basically the First Amendment Act was challenged, and in the Shankari case the Supreme Court held that socio-economic justice is important. The idea of welfareism was important, and that is why the specific amendments can be justified, and the Parliament has the power to amend the fundamental rights. Then the matter again came to the Supreme Court. In the Sajjan Singh versus State of Rajasthan case, (1965), the Supreme Court upheld its earlier judgment. In the Sajjan Singh case, the Supreme Court upheld its earlier judgment. Means the same judgment was upheld. Then, in the Golaknath versus State of Punjab case, 1967, an 11 judges bench of the Supreme Court by a majority of 6:5, by a majority of 6:5, held that the Parliament has no power to amend the fundamental rights. I intentionally wrote 11 judges bench, 6:5, because some of you may not be knowing many technical things also. So it again, I say it will be a mechanical thing for you. You say when we go to the court, यहाँ भी एक basic चीज आपको बता दूं, then I'll proceed further. In the court, we have got benches of judges. आप कहीं भी साइड में लिख लेना as an extra knowledge जिनको नहीं पता है. Benches in a court. We have got single judge bench, as the name suggests, single judge bench. It consists of one judge, and single judge bench looks into the civil and criminal cases. Single judge benches are there in the high courts and in the subordinate courts. One judge will hear the case. Then division bench, two judges. Division bench also looks into the civil and criminal cases. Division benches are there in the Supreme Court and in the high courts. They will also be looking into the civil and criminal cases. In the Supreme Court, all the cases are heard by a division bench. Two judges will be hearing. If it is a special bench, then 2 + 1. 3 judges will also be there. It completely depends on our Chief Justice. Then in the High Court also there can be special benches. That depends on the Chief Justice of the High Court, 3 judges. Then Constitutional Bench. Five or more than 5 judges. Interpretation of the Constitution. Or a law. Electoral bond scheme. It was reviewed by 5 judges bench. So whenever their matter comes related to the interpretation of the Constitution, 5 or more than 5 judges, here decision is arrived at by majority vote. That is why it is always there in the odd numbers. In the Golaknath case, 11 judges were there. और आपको एक चीज और बताता हूं. The revision of the judgment, the earlier judgment, it has to be by a higher bench. It has to be by a higher bench. And suppose the same type of cases come before the Supreme Court again, the Chief Justice of India, if he feels that the judgment can be changed, then he can constitute a higher bench. So in the Golaknath case, 11 judges were there. The judgment was 6:5. 6 judges were in the judgment that you said. Now in this case, the Supreme Court gave another doctrine. That is doctrine of prospective overruling. ये भी लिख लो. The Supreme Court in this case gave the doctrine of prospective overruling. That is, the judgment will have a prospective effect and not a retrospective effect. And not a retrospective effect. Because it was contended that your lordships, in the Shankari Prasad and in the Sajjan Singh case, the Honorable Court had held that the Parliament has the power to amend the fundamental rights. Many people would have been benefited, many people may have lost. So, what next? The Supreme Court said, let bygones be bygones. जो बीत गई सो बात खत्म. So this judgment will have a prospective effect, that is from a future date, not from a back date. That is the doctrine of prospective overruling. Golaknath case was a turning point in the history of India, and it was a setback for the government also. Because in a parliamentary form of government, the laws are initiated by the executive. That is, okay, we need to amend the fundamental rights, we need to do this. Now you are saying that it is against Article 13, Clause 2 of the Constitution. So we will not be allowing you to do that. Then from here, the tussle started between the legislature, that is the executive, and the judiciary. And in response to the Golaknath case, the Parliament passed the 24th Amendment Act. So what is the 24th Amendment Act? You can write it. The 24th Amendment Act 1971 added Article 13 Clause 4 added Article 13 Clause 4, which holds that an amendment to the Constitution under Article 368 not to be considered as a law for the purpose of Article 13. 13 means Article 13 Clause 2 specifically, but Article 13. Now, before I proceed here, ये भी बहुत ही मैकेनिकल, पढ़ोगे किताब से तो ऐसे भी समझ में नहीं आएगा है क्या. You see, first thing that you need to remember that Article 13 Clause 4 was added. In the original Constitution, this article was not there. Now, what is mentioned in Article 13 Clause 4 is that if an amendment is made in the Constitution under Article 368, it will not be considered as a law for the purposes of Article 13. Means it is a law for other purposes, but not for Article 13. Means wherever the word law is mentioned, if an amendment is done, it will not be considered. Now you will say, sir, what is this? ऐसे भी कहाँ समझ में आएगा तुम लोगों? आया नहीं आया? देखो, अभी 1 मिनट लगेगा, you will be able to understand it. I will ask you a general question. If an amendment is made in the Constitution, if it is a law or not? Of course it is a law, constitutional law, anti-defection law. Added in the 10th schedule, it is a law now. Then right to education is a law now. 73rd Amendment Act, it is a law. So the general understanding is that an amendment is a law. But in Article 13 Clause 4, it is mentioned that an amendment, I have used my own words because the constitutional language can be difficult for you. A law under, we can say if an amendment is made, it is not to be considered as a law for the purposes of Article 13. It will be a law for other purposes, but not for this purpose. What is the logic? Suppose you people are the parliament. You amend the fundamental right. Now, that amendment is challenged before me. I am the Supreme Court. I will say that I am going to declare your amendment as null and void, your law as null and void. Then you will say, sir, why? I will say it is violation of Article 13 Clause 2. Because Article 13 Clause 2 says the state not to make any law which takes away or abridges the fundamental rights. You people have made a law which has taken away or abridged these fundamental rights. So I am going to declare your law as null and void. Then you will say, sir, in Article 13 Clause 4 it is mentioned that, in Article 13 Clause 2 it is mentioned that the state not to make any law. Sir, we have not made any law. We have amended. We have done an amendment. Here it is written law, but we have not made any law. We have amended. Then I will say, hey, where it is written that an amendment is not a law? You will say, sir, Article 13 Clause 4. It is mentioned here. Now you see, in this way, the Constitution used to be manipulated earlier. You can change the words so that if it is challenged in the court, ये तो क्या हुआ? बिना बात का बहस हुआ ना? अरे, you are holding the nose like this. You are making a law saying that an amendment is not a law. You have written here. So it will not be the constitution, because it is mentioned now in constitution, it will not be unconstitutional. That is one thing. Then secondly, one more change was there. You can write it. The nature of Article 368 was changed. The nature of Article 368 was changed. And the Parliament was given the power, to amend any part of the Constitution. And the Parliament was given the power to amend any part of the Constitution. So earlier it was mentioned in Article 368, power of the Parliament to amend the Constitution. An amendment was made, power of the Parliament to amend any part of the Constitution. Any part will include the fundamental right also. आपने लीजिए any, so there will be no confusion now. This Constitution has given the power to amend any part of the Constitution. This Amendment Act was challenged in the Supreme Court in the famous Keshwanand Bharti case. In the Keshwanand Bharti versus State of Kerala case, it is only for the purpose of continuity I have written. If Keshwanand Bharti case, it's a landmark case. 13 judges bench or the Supreme Court, it was a 13 judges bench. In the Keshwanand Bharti case, the Supreme Court gave the judicial innovation of the basic structure doctrine The court held that the Parliament has the power to amend any part of the Constitution, but the basic structure not to be disturbed. Full stop. One more sentence we need to write here. The Supreme Court in this case did not elaborate on what constitutes the basic structures of the Constitution. What constitutes the basic structures of the Constitution? But in the judgments given in the future, it has held that the following aspects constitute the basic structures of the Constitution. The following aspects constitute the basic structures of the Constitution. Underline following aspects. So, in the Keshwanand Bharti case, the list of the basic structure doctrine was not given. But in the future, that is, for example, in the Minerva Mills case, the Supreme Court said that the balance between the fundamental rights and directive principles was a part of the basic structure. Then in the S.R. Bommai case, the Supreme Court said that secularism was a part of the basic structure. Then in L. Chandra Kumar case and in some other cases, the Supreme Court said that judicial review is a part of the basic structure. Then in the NJAC Act case, the Supreme Court said independence of judiciary was a part of the basic structure. So that is what we have written in the different judgments. So by following the, we can say, the judgments, we got that list. So the list has not been mentioned anywhere. It completely depends on the Supreme Court. It is an evolving list. So what are the basic structures? Let us have some ideas. First, the sovereignty of India, then ideal of a welfare state, ideal of a welfare state, federalism, secularism, rule of law, supremacy of the Constitution, judicial review, then independence of judiciary, हाँ मैं रट के आया हूँ, घबराओ नहीं, पूरे रात भर रटता हूँ यार और तब पढ़ाता हूँ सब। सेपरेशन ऑफ पावर्स, क्या सोचते हो सर, भूल गए हैं? हाँ, तुम लोग अपना एग्जाम, तुम लोग प्रैक्टिस यहाँ मत करो, हाँ अभी पता चलेगा, अभी एग्जाम पहले दो। हाँ तो रट के आया ही हूँ। सेपरेशन ऑफ पावर्स, इसको बोलते हैं थर्ड ईयर सिम्टम। मेडिकल साइंस में, मेडिकल में जो बच्चे थर्ड ईयर में पढ़ने लगते हैं ना, वो दवा प्रेस्क्राइब करने लगते हैं। तो जो बच्चे कभी थोड़ा इधर उधर पढ़ लिए ना, वो क्लास में प्रॉम्प्ट करने लगते हैं। ये थर्ड ईयर सिम्टम बोलते हैं हम लोग। बैलेंस बिटवीन द फंडामेंटल राइट्स एंड डायरेक्टिव प्रिंसिपल्स। Then republican and parliamentary form of government. Now from here the questions can be asked in the examination. Which of the following is correct regarding the basic structure? It is a judicial innovation. ऐसा आ सकता है, the basic structure doctrine is a social legislation, social innovation, executive innovation, a legislative innovation, judicial innovation. It is a judicial innovation. Then who is to decide that what are the basic structures? It is the Supreme Court which has to decide that what are the basic structures. Then which of the following are the basic structures of the Constitution? These are some of the basic structures. अगर ऐसा भी आएगा द बेसिक स्ट्रक्चर इज स्टैटिक, नो इट इज नॉट स्टैटिक, इट इज इवॉल्विंग, इट इज डायनामिक. It so basically the understanding based questions will be there in the prelims examination on the basic structure doctrine. Then this doctrine basically was upheld by the Supreme Court in the Minerva Mills Limited case. So last में लिख लेना, the Supreme Court in the Minerva Mills versus Union of India case, ये मैं ऐसे ही लिख रहा हूं for continuity, versus Union of India case 1980 upheld basic structure doctrine. Now I'll make you to revise it so that you will not fumble and you'll have an idea that what type of questions are asked here. First, the question can be with respect to the First Amendment Act. This is the First Amendment Act, 2 articles and 1 schedule. Then, in which of the cases the Supreme Court held that the Parliament has the power to amend the fundamental rights? What are the cases? Shankari Prasad and Sajjan Singh. You need to remember that only. Never try to remember everything. Then, in which of the cases the Supreme Court held that the Parliament has no power to amend the fundamental rights? Golaknath case. Clear? Doctrine of prospective overruling. Golaknath case. Then, questions can be asked on the 24th Amendment Act. So Article 13 clause 4 was added and then Parliament was given the power to amend any part of the Constitution. Then basic structure doctrine, Keshwanand Bharti case, and the judgment of which of the cases was upheld in the Minerva Mills case? The judgment of the Keshwanand Bharti case was upheld in the Minerva Mills Limited case. See the last 10-15 year question papers. Not a single question has been asked outside from it. This is the summary. Done. There is no need to read more because when we are on this side, we can torture you that you need to read everything. But suppose you are on that side, you have to read 10 to 12 sections of the general studies paper. You cannot be an encyclopedia. You will have to develop that aptitude to grasp the things. So that is why you need to read less but grasp more. That is the mantra of success. It is not that you should read more and more. You cannot be an encyclopedia. No one can be an encyclopedia. Teacher के लिए तो बहुत आराम है, बोल देगा यहाँ खड़ा होके, उसे मुझे तो एक ही सब्जेक्ट पढ़ाना. But you have to read everything. So you need to develop them. One more question. You say here what we had discussed. एक एक चीज आपको बता देता हूँ. 9 schedule and Article 31B. Social legislations and a law added or a matter added in the 9 schedule is not subject to judicial review. In the Keshwanand Bharti case, the Supreme Court gave the basic structure doctrine and judicial review is one of the basic structures. The Supreme Court has said. And Article 31B says that a matter added in the 9th schedule not subject to judicial review. अब क्या होगा? The matter went to the Supreme Court with respect to the status. It is a question of the UPSC examination. You can write as note. The Supreme Court in the IR Coelho case, 2007, held that the laws added to the ninth schedule, by amendments made after 24th April 1973, that is the date of the judgment of Keshwanand Bharti case. ब्रैकेट में लिख लो जिसको नहीं आता, नहीं पता है. It is a date of judgment of the Keshwanand Bharti case. Are subject to judicial review. ये हो गया. So till 1973, 24th of April, whatever subject has been added in the ninth schedule, you cannot challenge it in the Supreme Court. That is not subject to judicial review. So the summary here, one more sentence can be there. देखो, I said understanding. ये तो direct judgment is there. So what is the understanding? You can write here in the next sentence. The ninth schedule is subject to partial judicial review. The Supreme Court is subject to partial judicial review. Partial, not fully. Partial मतलब 1970 judgment के बाद जो भी आया. So what had happened basically was that the Tamil Nadu government had provided for more than, कितना रिजर्वेशन है तमिलनाडु में, कितना है? What is the Supreme Court limit for reservation? 50%. And Tamil Nadu, the reservation is 67 or 69%, and it was added in the ninth schedule. The matter went to the Supreme Court that you have mentioned that the upper limit will be 50%. इसमें the states will make laws, they will add in the ninth schedule, and it will not be subject to judicial review. The Supreme Court said okay. Then the Supreme Court said that it is subject to partial judicial review. Any matter that has been added after 24th April 1973, it can be questioned in the court, and we can look into the validity of such statements will be there with respect to the ninth schedule in the Constitution. बाकी ninth schedule से और कोई question आपके एग्जाम में नहीं आएगा except this statement. So here, with respect to basic structure and the ninth schedule, you see we need to correlate the things. Then it will be polity. Otherwise, it will be only a constitution. Till now, we have not discussed a single fundamental right. But if you see the previous year question papers, most of the questions are asked from these areas: human rights, nature of fundamental rights, judicial review and fundamental rights, and then amenability of the fundamental rights. So that is why we gave more emphasis on these aspects, because if you develop an understanding, then you will be able to answer the questions. Then now coming to the classification of the fundamental rights. We all know that there are 6 categories of fundamental rights. So some of the fundamental rights have to be discussed in detail, some in very brief, just to have a continuity. Right to equality. Your heading will be classification of the fundamental rights. Articles 14 to 18. Coming to article number 14. Article 14 provides for 2 types of equality. Equality before law and equal protection of laws. Two types of equalities. Now, one by one, we will be looking into it. First of all, coming to this equality before law. Equality before law has been taken from the UK Constitution. It means no one is above the law all are equal in the eyes of law. Whether a person is rich or poor, he is a government servant or a common man, laws are equal for everyone. Then it is based on the concept of rule of law. You see, rule of law, it establishes supremacy of law. We call it as lex superiorus. Law is supreme. This concept of rule of law, lex means law. This concept of rule of law was propounded by Aristotle. This is one of the contribution of Aristotle to political philosophy, the concept of rule of law. And Aristotle was of the view that rule of law was better than rule of men. And in the absence of the written laws, even the most honest magistrate may not be honest. That is why there has to be laws according to which the magistrates, the judges, they should rule. So that is the concept associated with the name of Aristotle. But in the modern times, this concept of rule of law was popularized by Professor A.V. Dicey. So propounded Aristotle, popularized by Dicey. ये चीज है, समझ गए ना? ये अंडरस्टैंडिंग इज इंपॉर्टेंट, क्योंकि दुनिया सिर्फ वो डाइसी साहब का नाम जान रही है, लेकिन वो मेरे एरिस्टोटल का नाम भी जानना है ना, ही इज द फादर ऑफ पॉलिटिकल साइंस. तो इसी के चलते हमारा घर परिवार चलता है, तो वी नीड टू नो हिम ऑल्सो. और मैं बताता हूँ सबको कि नहीं नहीं अरिस्टोटल भी है, अंग्रेजों का नाम तो सबको मालूम है. सो हियर it was popularized by the English scholar Professor A.V. Dicey. A.V. Dicey. So, what A.V. Dicey had done, A.V. Dicey had talked about certain postulates of the rule of law. लिख लो इसको भी, कभी एग्जाम में कहीं डिटेल में पूछ देंगे, क्योंकि रूल ऑफ लॉ इज इटसेल्फ अ कॉन्सेप्ट व्हिच इज very much asked in the examinations other than equality before law, उससे भी अलग करके पूछते हैं. So in the next point you can write Dicey talked about three aspects of rule of law. Three aspects of rule of law. First, supremacy of law. Secondly, equality before law. And third, predominance of the legal spirit इतने याद रखना है, मैं समझा देता हूं बाकी, क्योंकि ना एग्जाम में द थिंग शुड नॉट बी एलियन टू यू, ये हमेशा ध्यान रखना है कि हाँ कम से कम है कि एटलीस्ट यू विल बी एबल टू relate the things here and there. The first thing we have written, supremacy of law. The law should be supreme. And here what dicey specially means, बहुत लिखा ना, इतनी मोटी किताब लिख दी. So basically when we talk about dicey, he was of the opinion that there should be lesser discretionary powers on the part of the decision makers, because if the more discretionary powers will be there, then the written law will not be valid. So there should be lesser discretionary powers, and the law which is prevailing, that should be supreme, and everyone should abide by that law. That is supremacy of law, lesser discretionary power, and those who are enforcing the law, they should also abide by the law. When we say equality before law, there should be no separate courts for the common man as well as for the officials. And everyone should be, we can say, treated equally before the law. And then predominance of the legal spirit. In most of the constitutions of the world, we have got the provisions against arbitrary arrests. That is, no one to be detained arbitrarily. But it is being done. So what is the spirit behind it? That is not to punish those who are innocent. That is the legal spirit. So the spirit behind the laws have to be followed. It is not that the law should be there only on pen and paper. The spirit, the idea behind the law has to be respected. That is predominance of the legal spirit. आपको भी ये ध्यान रखना है. अगर आपसे कोई पूछेगा ना मेंस में जब जाओगे इंटरव्यू के लिए कि हाउ यू विल अप्लाई द रूल ऑफ लॉ, आप ये नहीं बोलना कि रूल ऑफ लॉ कंसिस्ट ऑफ ओनली वन थिंग. नो नो सर, आई विल डू दिस. ये नहीं. रूल ऑफ लॉ सर, बेसिकली फर्स्ट ऑफ ऑल I will be using my discretionary power very less, and I will go by the laws which are there. Then sir, I will treat everyone equally. That is concept of equality before law. And sir, I will ensure that the laws do not exist only on pen and paper. The legal spirit should prevail. पेपर 4 में जब एथिक्स का पेपर लिखोगे ना, ये सब काम आता है. How you will be solving the question. So that is what I said कि prelims के लिए तैयारी करोगे ना, so you need a holistic idea about the things. So if an idea is there, now if a question is asked, you will be able to answer the questions. This was related to the concept of equality before law, a bit understanding. Some people are there who are above the law. Means the rule of law is not valid, they are not punished in accordance with the law of the land. For example, the president and the governors, they are not answerable in any court of law for the administrative decisions that they have taken. These are the exceptions to equality before law. लिख लेना, exceptions. Exceptions to equality before law. First, the president or the governor of a state not answerable in a court of law for the administrative decisions taken by him. Secondly, no criminal proceedings can be initiated against the president or governor of a state during the term of office. And thirdly, the foreign diplomats and the visiting foreign dignitaries are not to be punished according to the law. It is known as diplomatic immunity. It is known as diplomatic immunity. So if a foreign diplomat is here, even if he is involved in a criminal case, then he will just be asked to leave the country within a reasonable time. 24 hours, 48 hours, जो भी time देंगे. He cannot be punished in accordance with the law of this country. This immunity is there with our diplomats also. If you will be an IFS officer posted outside India, you will be enjoying this diplomatic immunity. ये भी आपको ही मिलेगा, घबराना नहीं है. वहाँ मर्डर भी कर दो, कोई टेंशन नहीं. But you will be tried in India. So these are the exceptions. Now coming to equal protection of laws. This concept of equal protection of laws has been taken from the US Constitution. And it means likes to be treated alike equality under equal circumstances or we can also say it is equality among the equals. Equality among the equals. Now you see the beauty of the Indian Constitution. two different aspects. One is equality before law, taken from the UK Constitution, which means that there should be legal equality, all should be treated equally before the law, and likes to be treated alike. Under equal circumstances only there will be equality. This concept has been taken from US Constitution, and they have been combined together to make our Constitution a coherent one, this article a coherent one. Here, when we say equal protection of laws, if you talk about equality before law, you will not be able to give complete justice to a person. That is why equal protection of laws is required. Suppose if two persons have committed murder, but under two different circumstances, and if you punish them equally, equality before law, then justice may not be given to one. The one person may have killed someone in self-defense or protecting the other members of the society, and the other one is a professional killer. So yes, that is, circumstances are different. So here, equality has to be only among the equals, not among the unequals. So that is the beauty of the Indian Constitution. That is why we remember Dr. Ambedkar for giving us a very good Constitution. You see, this part taken from this Constitution, this part taken from this Constitution, and they have been clubbed together to give it an Indian color. So this was Article 14. We needed to know this much. Emphasis will be on rule of law. Then coming to article number 15. Article 15 is available only to the citizens. Only to the citizens. Article 15 clause 1 prohibits the state from discriminating against the citizens on the grounds of religion, caste, sex, race, or place of birth. There is no need to mug up. No one is going to ask you article number 15. It's continuity ke liye I have told you. Now the question is, where there shall be no discrimination on these grounds. And you see, the discrimination shall not be in the use of in places like hotels, restaurants, then theaters, that is the places of public entertainment, or the use of wells, tanks, bathing ghats. So देखो इसको कैसे you need to remember. There is no need to mug up. Achha, the teacher today discussed article 15. He said article 15 is there only with the citizens. In your mother tongue you need to remember it. And then he said that the state on certain grounds should not discriminate among the among the citizens. Even if you forget the grounds, it hardly matters. The place of birth, religion, caste, kuch to yaad rahe. Then where the discrimination will not take place, in the hotels, public restaurants, then places of public entertainment, use of wells, you just need to remember like this. No one is going to ask you, hey, what is article 15? It is for your understanding that, okay, this is the understanding of article number 15. Now, but there are some exceptions to it. How many of us travel by Delhi metro frequently? How many of us? He also many times. The first coach towards the engine is reserved for women. It is violation of Article 15 clause 1 or not? Yes sir. देखो Supreme Court भी जाओगे क्या? So that is what I said. There are exceptions. To Article 15 clause 1. There is no need to mug up the articles paragraph. First, Article 15 clause 3, special provisions can be made for women and children. अब मत जाना सुप्रीम कोर्ट. Women and children. Then Article 15 clause 4, special provisions can be made for socially and educationally backward classes including scheduled castes and scheduled tribes. Then Article 15 clause 5, reservation for socially and educationally backward classes in educational institutions that is private also. गवर्नमेंट में तो है, प्राइवेट ऑल्सो. Aided or unaided by the state, except minority educational institutions. ये अंडरलाइन करना, एक्सेप्ट माइनॉरिटी एजुकेशनल इंस्टीट्यूशन. So there may not be reservation for scheduled castes, scheduled tribes or the OBCs in the minority educational institutions. Then Article 15 clause 6. ये सुना तुम लोगों ने आर्टिकल 15 क्लॉज 6? दो क्लॉजेस हैं. द फर्स्ट क्लॉज, स्पेशल प्रोविजंस कैन बी मेड फॉर इकोनॉमिकली वीकर सेक्शंस So here it is only for the general category, economically weaker sections other than the categories mentioned in clauses 4 and 5. Means it should be for the general category, economically weaker section. And then secondly, reservation for economically weaker sections in educational institutions यहां पे भी द सेम लॉजिक, एक्सेप्ट माइनॉरिटी एजुकेशनल इंस्टीट्यूशन, कहीं भी है ना रिजर्वेशन, तो इट इज माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस आर एक्सेप्शंस. So reservation for EWS in educational institutions, but here one thing we need to remember, that the reservation shall not be more than 10% in each category. It shall not exceed 10% in each category. अब BA ऑनर्स में है तो BA ऑनर्स पॉलिटिकल साइंस 10% सीट्स रिजर्व फॉर इकोनॉमिकली वीकर सेक्शन. इट इज नॉट कि पूरे कॉलेज में आप इकोनॉमिकली वीकर सेक्शन के लिए 10% कर दो. इट कैन बी ओनली फॉर वन सब्जेक्ट. So 10% in each category. MSc Physics 10%, MSc Chemistry 10% for economically weaker sections. ऐसे करके है. और यहां पे क्लियर लिखा है it should be above the reservation which has been prescribed. So that is why this was not declared as null and ऐसे याद रखना. अच्छा, special provisions for the women children can be made. Then for the scheduled caste and the scheduled tribes. Then reservation in higher education, reservation in education for the educational institutions for the socially and educationally educated. Then special provisions for economically weaker section. ये first part. Second part. It was there in the original constitution. These were added by amendments. So you need to remember the amendment number here. Article 15 clause 4, it was added by which amendment act? लिख लो, First Amendment Act. First Amendment Act. Then Article 15 clause 5 added by the 103rd Amendment Act. 103rd Amendment Act. सॉरी, ये 93rd है, ये 103rd. सॉरी, 93rd and this is 103rd. 103rd Amendment Act. ये तो लेटेस्ट है, you may be knowing it. 2019. Before the last general election, it was the gift of the outgoing government. हाँ, रिजर्वेशन कहीं भी, हर एक जगह पे जहां भी एजुकेशनल इंस्टीट्यूशन में रिजर्वेशन है ना, ये क्लॉज होगा, एक्सेप्ट माइनॉरिटी एजुकेशनल इंस्टीट्यूशन. हाँ, यहां पे मे है तो ये उनके ऊपर डिपेंड करता है. इफ दे विश टू गिव रिजर्वेशन दे कैन गिव, दे मे. So, for example, in Aligarh Muslim University, there is no reservation, so it can be. हाँ, unaided with, aided और unaided, एकदम लिखा हुआ है आर्टिकल में. हाँ, नहीं, ये डिपेंड करेगा. It may be. So your state will decide. Your state will decide. एजुकेशन तो ऐसे भी स्टेट गवर्नमेंट में आएगा, तो वो लोग डिसाइड करेंगे कि आप क्या कंपलसरी कर रहे हो, नहीं कर रहे. स्कोप दिया हुआ है. दिस वाज वी कैन से. सो यू नीड टू रिमेंबर लाइक दिस. इसमें मगअप नहीं करना है. यस, बट यू नीड टू रिमेंबर द आर्टिकल नंबर्स. 93rd Amendment Act, 103rd Amendment Act. Which of the following is correct regarding the 103rd Amendment Act? So wherever you will find economically weaker sections, it is 103rd Amendment Act. Even in Article 16, we have got this economically weaker section, reservation का. वो भी मैं आज आपको करा देता हूं, फिर एक इकट्ठा चलेंगे. आर्टिकल 16, it is available only to the citizens. Only to the citizens. It is equality of opportunity in public employment. इन पब्लिक एम्प्लॉयमेंट गवर्नमेंट जॉब। ये भी नहीं पूछते हैं एग्जाम में, ठीक है ना, फिर एक आइडिया आपको मैं दे दे रहा हूं क्या है क्या नहीं है। तो आर्टिकल 16 क्लॉज 2 देयर इज नो नीड टू मग अप, उसमें सिर्फ इतना ही लिखा है कि द स्टेट शैल नॉट डिस्क्रिमिनेट अमंग द सिटीजंस ऑन सर्टेन ग्राउंड्स। यहां पे रेसिडेंस हैज बीन एडेड, डिसेंस हैज बीन एडेड हियर। नाउ व्हेन वी टॉक अबाउट एक्सेप्शंस, exceptions. First, residence can be a qualification for certain jobs in a state or union territory. The parliament has been authorized to make laws related to it. Then reservations may be there or may be provided by the state to the socially and educationally backward classes, socially and educationally backward classes which in the opinion of the state, which in the opinion of the state is not adequately represented, in the services under the state. ये देखो इनेबलिंग क्लॉज है, सो नोवेयर इट हैज बीन रिटन शैल। सो एक और, तो अब देखो ओरिजिनली द रिजर्वेशन वाज गिवन टू द शेड्यूल कास्ट एंड शेड्यूल ट्राइब्स, then the Mandal Commission recommendations were given when Indra ji was the Prime Minister, but it was implemented by Sri VP Singh. So it completely depends on your state. So reservations may be provided by the state for the backward classes of citizens. ये है आर्टिकल 16 क्लॉज 3, 16 क्लॉज 4, then 16 clause 4A, reservation in promotion or reservation for scheduled caste and scheduled tribes in promotion. So there is a provision for reservation in promotion, जो बहुत जरूरी है ना, वो मैं तुमको बता रहा हूं, ऐसे थोड़े नॉलेज के लिए भी चाहिए होता है, that is why. And then Article 16 clause 5 is useless for you. 16 clause 6, reservation for economically weaker sections, for economically weaker sections. Here also maximum 10%. There is no need to mug up. 103rd Amendment Act. Clear? Wherever it is economically weaker section, it is. दो छोटे छोटे और आर्टिकल्स, I will take 3 minutes. Article 17 लिख लो. Article 17 abolishes untouchability. ये हो गया Article 16. ये सबसे ज्यादा सवाल नहीं आएंगे. Article 17 abolishes untouchability. Then Article 18 Article 18, Clause 1 prohibits the state from conferring titles on the individuals except military and academic distinctions. Except military and academic distinctions. ये नहीं पूछेंगे आर्टिकल 18 क्लॉज 1. इससे देखो दो चीजें नोट में लिखना. फर्स्ट, the national awards were introduced in 1954 but were discontinued in 1978. So when the Janata Party government had come, they were discontinued and they were again revived in 1980. लिख लो, they were again revived in 1980. In 1978 and were revived in 1980. 1980. Then again, basically, for some years it was discontinued. So based on this, there was a statement once in the prelims examination. Which of the following statement is correct? The national awards were temporarily suspended. Temporarily. तो क्या हुआ था कि 90 the Bharat Ratna is routed through the Prime Minister's office. When Panditji was the Prime Minister, he got Bharat Ratna. I said Bharat Ratna is to be routed through the PMO. The Prime Minister will recommend the President that this person should be given the Bharat Ratna. But Pandit Nehru, when he was the Prime Minister, he got Bharat Ratna. Then Indira Ji also. When she was the Prime Minister, she also got Bharat Ratna. When the Janata Party government came, he said, these people are using family business. They are using just like a, we can say, title for the family. So they discontinued it. ये story मैं जानबूझ के students को बताता हूँ. Why? There is a hearing impact. This statement was asked in the examination. मुझे क्या मालूम था, कहानी में बताता हूँ, आ जाएगा exam में. Yes. So students who had heard the story, sir had discussed it, that it was discontinued by the Janata Party government because of this reason. And when Mrs. Indira Gandhi came to power in 1980, she revived it. So temporarily suspended. Temporarily discontinued. So such type of question. Easily I said it is polity. You'll have to develop an understanding. Then note number 2 you can write. In the Balaji Raghavan case, you need to remember the name of this person. He will give you jobs. Balaji Raghavan. In the Balaji Raghavan case, the Supreme Court held that the national awards are not titles but are awards. We also know, and to know this, Balaji Raghavan had gone to the Supreme Court. Whether these are rewards or these are titles. The Supreme Court said that these are conferred on the individuals for rendering service to the state or to the society. So these are not titles. But we have got this code. That is, we are not supposed to use it as suffixes or prefixes. So by default, if you get Bharat Ratna, you are not supposed to Bharat Ratna and then you will write your name. नहीं करना गलती से भी, मैंने बता दिया. But it is not penal in nature. There is no penalty for it. The government of India or the state government will just issue a letter to you that, sir, according to the Supreme Court judgment, you are not supposed to do this. It is not penal in nature. So target completed today. I had targeted to discuss till Article 18 of कॉन्स्टिट्यूशन, क्योंकि वो 7 days का है ना हमारा, 7 days, तो ऐसे तो जिंदगी भर पॉलिटी पढ़ाते रह जाऊंगा, तो we'll have to be disciplined also. So today's target accomplished. Tomorrow from article 19 we will start. We'll stop here for the day.